Well, this is gonna be fun. I love that music. Do you love that music too? Yes, it is Zydeco. Somebody asked me that one day in the comments, and I thought it was so appropriate. You know, I'm a music lover, and it reminds me of Little Feat. Anybody remember the band Little Feat? Or is anybody a Little Feat fan? Oh, this is gonna be a fun show today, you guys. I can just feel it. I can just feel it in my bones. I watched this hearing yesterday, and I was spun by what was going on at the hearing, but at the very same time, thank you to so many of you and to my team who discovered a very credible threat against me for apparently having opinions on this case. So that was a day well spent yesterday with reports and interviews and all kinds of things that need to be done in those types of situations. But what it does is fuel me just a little bit more. So if you think you're going to shut me up by doing such things like that, and you know who you are, you're not. You have that man in the bathtub. That is right, Melanie Parker. That is right. I have an amazing team. An amazing team. Many of them are retired law enforcement. And when somebody out there threatens my kids, we got a problem. So I think what we're going to talk about today, we're going to talk about that at the end. And we're going to have a little refresher on the law of defamation in New York, because I'm located in New York. There seem to be a lot of creators out there and a lot of twidiots who don't really understand the difference between fair use and defamation. So I thought today would be a great day to do that at the end of the stream. So hang on to your seats for that one. And we'll see how much stuff gets deleted in the meantime. So yesterday's hearing was quite, I know that you guys are going nuts and you're like, we got to talk about this. We got to talk about this, because I was watching it in a couple of different places. And I can't recall exactly where. I was with Brandy, I believe, for a while. And I got called away to deal with all this other nonsense. And then I think I needed some comic relief. So I went back and watched Glare for a while. And I think I was with CPU, Tom CPU in the morning. Oh, do not poke the mama bears. Oh, don't do it. In Lucky We Trust. Oh, what? You don't like my pink sparkles? Do you think making fun of my pink sparkles is going to upset me? Really? Because if that's the best you got, you know that you got a pretty pathetic existence. Pathetic. Pathetic. Oh, and it's on. You know what makes me really, really angry is when other women go after successful women. There's a special place in hell for people like that. We're going to pull up a couple of examples of that later, but one of the most egregious examples that I've come across in quite some time was the discussion of what Karen Reed wore to court yesterday. Are you kidding me? By someone with a huge following who is supposed to be an expert? Do you know what I'm talking about? Do you know who I'm talking about? Yeah, keep the names out of the chat for now. But when you're going to come after me personally, game on. When you're going to try and ruin my reputation and my professional license, game on. And people are trying to pull Karen down for wearing a nice blazer. Are you kidding me? It's so funny because I saw her wearing that black blazer. I'm like, oh, Veronica Beard, I love that blazer. I love that. You know what? Karen Reed is a self-made woman. Okay. She never had a man supporting her. She's not one of those stay-at-homes eating bonbons who don't have to worry about money and get to sit at home and play tennis while their significant other goes out and busts his ass to support the family. And I can relate to that. Okay. So there are a lot of us out here. And when you start tearing down women like that, it makes you look like a fool, like an absolute fool. So keep it coming, because justice is coming too. And last night I watched, and if you haven't seen it, don't go watch it now, but I'm going to highly recommend this to you. Defense Diaries did a show last night on Karen Reed. Husband and wife team. And listen, when you're a creator, you don't get to watch a lot of other creators. You just don't. And Brandy said this to me because Brandy and I, if you don't know Brandy Churchwell, she's amazing too. She's got all the charts or all the graphs, all of the family trees in this case. So if you're just jumping into this case, you're going to want to go look at Brandy's stuff later, not right now. And people kept mentioning us to each other. And so we finally got together, we did a show, and she's amazing. And so she brought up Defense Diaries to me and Bob Mata, Bob and Allie. And I went into their chat last night because they were talking, it was late and I couldn't sleep. And I had a great time over there. And hopefully I'm going to do a show with Allie soon. I love her. She reminds me of Catherine Zeta-Jones. And she is my jam. And I think that two women lawyers doing a stream together would be something that I have been waiting for a long time. So if you don't know Allie Mata, go check her out. Her husband's cool too, but Allie's my jam. So I don't know if you guys are here, but probably not because it's like during the workday still. But yes, playoff hockey is happening tonight. The Rangers are playing at 7. So, I got to get out of here for that at some point. But you know what happens is I get talking and then we get sidetracked and then I get mad and then I tell you how I really feel. And today's going to be no exception. Trust me when I say that. Oh, my friends, how are you? I know it's been a rough day. Maureen Francis, as always, thank you so much for getting in here with your contribution before the stream even started. My dear, you are a staunch supporter and I thank you so much for that. You guys, your emails really keep me going because there are days where I'm like, I'm not even going to do this anymore. Like, what is the point? Like, do people think I'm making Ruby Frankie money over here? Like, millions and millions of dollars from sharing my opinions with you and hanging out with you for a couple hours every day? No, but, some people seem to think I'm in it for the money and we're going to look at that as well. So that'll be fun. All right. So, and I usually don't stoop to that level, but I am now at the point where, you're going to come for me in a defamatory kind of way. We're going to discuss the law. I'm going to let you guys decide where you think this is, what side of the law you think this is on. Yeah, exactly. Thank you. Thank you, Chief Sherry. Women are terrible to women. We need to be supporting each other. I went through this as a female fire chief in Massachusetts. Good on you, girl. I mean, not good that you had to go through this, but good on you for dedicating your life to saving lives. Other women were the worst, saying I only got the job because I was a token. Yeah, or because, maybe you slapped your way to the top, right? Isn't that what they always like to say too? Because there's no way that you could possibly be successful on your own. I mean, that just couldn't happen. In fact, I had my own name on a law firm in my 20s, and I had a male partner, and we were friends since grade school. And people assumed, first of all, that we were married, because how could I ever be a partner in a law firm that young without being married to the other guy? And we were married, just not to each other. And they also thought that because it had my name on it, the law firm, it must be my daddy's law firm. That was the other thing. And the other thing I dealt with in the 90s as a woman lawyer was the boys club, the old boys club, men attorneys. I would walk into the courtroom or the deposition room to do a deposition, and they would say, okay, honey, you could set up over there in the corner, assuming I was a court reporter because I was a woman. So I've been through it. And it's disgusting. And the fact that in 2024, I'm still talking about it and I still see it happening publicly to other women is disgusting. It's disgusting. It's gross. It's not classy. Intolerant. She won't watch you. She speaks directly from pure ignorance. I'm sure you know who you're talking about. She's a huge disappointment. Get her. Yeah, you guys know who I'm talking about. And I'm sure you know who those other creators are out there too, that like to make videos about me. That very well may be defamatory if they're intended to ruin my reputation and my profession, my career. So there's some feckless people out there, one millennial, another a Karen, and some others. But we'll talk about those guys later. Let's jump into this hearing. I don't think we need to watch the whole entire thing. I am bringing us to around 30 minutes into this hearing. It's about 2 hours long. it's hard to speed it up because Lally talks so fast that if we speed him up, it sounds like you know, he's on a helium tank or something. So we are outraged, Kate. We are outraged. But you know what, Kate? This is what I say to myself. I say to myself, I know that I am on the right side of this. I know I am. I can feel it in my bones. I have, you know, my gut, everything that I have looked at in this case, the investigative reports, the documents, every piece of evidence we could get our hands on from the court file. It just points me to one conclusion. And the conclusion is a car did not hit Officer O'Keefe, and Officer O'Keefe was not hit by a car. It just wasn't. So that's my opinion. I'm sticking to it. And I have a feeling that my opinion at the end of this trial, if it gets that far, if it gets to verdict, is going to be verified. So if you don't like it, you don't have to watch it. And you also don't have to take little clips of what I say and make it into your cute little videos with people throwing up pink sparkles and, you know, distort my voice. It's just, what are you, a moron? You an idiot? Like, who does that? Like, what kind of world are we living in? I don't know. But there's so many of them out there that it's hard to even keep track. But all of you guys send it to me, so I have it. I quit Twitter because I couldn't deal with the vitriol and the nonsense and the hatred, and it's gross. Yeah, what are we, 12? Yeah, exactly. What are we, 12? The world is watching. Truth Seeker, the world is watching. And those people that have convicted Karen Read without a trial, including the people who are supposed to be your publicly elected officials over there in Massachusetts, as such, like your district attorney, in his public statement, it says a lot about what's going on in our world today. It really does. And it's very, very, very sad. And I see it in a lot of cases, not just this one. I think this one is so vitriolic because Karen Read is a successful woman, and I'm starting to see that more and more. At first, I didn't want to believe it, but that's what I'm seeing here. Brian Koberger, you know, but this is a case where I think so many people can relate to her, and it's not just women that are relating to her; it's men too. And I'm seeing it and I'm hearing it and I'm hearing you guys and you're writing to me and you're telling me your feelings and you're putting it in the chat and in the comments, and you are really, really vocal about it. And I'm glad that you're paying attention because this is not the only case I covered. And no, I am not paid by the defense. Okay. So people need to stop assuming that, accusing me of that. It's ridiculous. And really, if that's all you have, then, you know, why don't you try and look at the facts of your case instead of attacking the people who are reporting on it in a fair way? Because quite frankly, there aren't a lot of people out here doing this. This is an island that I'm on by myself. Some other law tubers have done shows here and there, but nobody's been covering this case like I have. If you know of any other attorneys that have been doing it, tell me, because I haven't seen them. But this is just, it's repulsive. All right. The first thing we're going to jump into here, let me go back to my notes. And if you have any questions about the motions that they heard before this was the hearing from yesterday in Norfolk Superior Court, Norfolk, Dedham, Massachusetts, Norfolk County. There were several of these motions in lemonade, as we're calling them now, because that's what the closed captions called them one day, that were stipulated to or allowed by agreement, as the judge likes to say. But they were stipulated to, so they are coming in. The 911 call, the something about a court reporter, a Zoom feed instead of a webinar, in-court identification, admission of the victim's photograph, admissions of the photos of the autopsy injuries. There are defendants' out-of-court statements and records from Good Samaritan Hospital. Those are typically allowed in as statements made contemporaneously with medical treatment and close in time to the event. So I didn't see a problem with that admission. There was something about leading questions with regard to the 16 and 13, or maybe they're 16 and 14 now, the niece and nephew of Officer John O'Keefe, whom he had adopted and had been raising. I don't know if there was a legal adoption, so don't hold me to that, but was their guardian for approximately 8 years. Tragically, his sister died of an illness, and then 3 months later, her husband died, and John stepped up to the plate and he took those children in, and they are 16 and 14, and the Commonwealth wants to call them as witnesses in this case to say that Karen and John had a contentious relationship, that they had been arguing before she murdered him, according to the Commonwealth, and that apparently whatever these children say is going to be motivation for murder. I think that's a very dangerous thing to do. I don't think it's, in my opinion, I don't think that it is the right thing to do, to call children into this, because they are going to live with this forever, that they were called into court to testify against a woman who they knew very well. And no matter what happens at the end of the day, this is going to be a trauma for them that they're not going to soon forget. And I haven't heard any talk about whether they are going to be allowed to be in chambers or something and their testimony streamed into the courtroom, or whether they are actually going to have to get up on that stand, raise their right hand, and then swear to tell the truth in front of a whole courtroom of people that they don't know, and cameras. And listen, apparently those are the only witnesses they have, in addition to these 4 people who are going to testify about things that they may or may not have seen in Aruba with regard to a New Year's Eve trip that was held at least 3 weeks before Officer John O'Keefe was murdered. And he was murdered. And they are going to come in and testify to things such as Karen and John arguing. He didn't want to get out of the pool. He wanted to watch the game, and Karen wanted him to get out and get ready for dinner. And then, some woman is going to testify that oh my God. Oh, I love you guys so much. I love this hell in a handbasket. Maybe instead of pink sparkles, they would prefer red taillight sparkles. Oh, that is beautiful. If anybody wants to make that emoji. Oh, I put some new emojis up, you guys, in the chat. So enjoy them. I have lies, 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 Thompson twins, lies, lies, lies. Yeah. There's a Steely, a Grateful Dead Steely, and there's a We Are Outraged. That might be a little bit hard to see, but it's like black and blue with white letters. So check them out. Feel free to use them. Give them a test drive. And yeah, maybe I'll make a taillight emoji. There should be, there are some we could do for, yeah, looking good. They look good, actually. They look really good. You can kind of read the We Are Outraged. I like it. Because we are outraged. We are outraged, and you're not shutting us up. So, okay, where was I? Oh, Aruba. Yeah. So there's a woman who's going to testify that Karen's an a-hole because she wanted her own bathroom. Meanwhile, she has Crohn's. She had, I can't even remember how many surgeries she has had on her colon, but a lot. And she's been dealing with several medical issues since the age of 25, including MS and a brain tumor. And she wanted her own bathroom in Aruba. And this woman is going to come in and testify that because of that, she thought she was an a-hole, and she just rubbed her the wrong way. And then there's an incident they're going to testify about or talk about where one of these women was in the lobby, and John came out of the elevator and hugged her. And then Karen said to John, "Who the F is she?" And then he said, "Oh, that's somebody's sister." And she said, "F you" to the girl. And the girl said, "F you back." And somehow that's a motive for murder too. 3 months before John was murdered. But this is what they have. This is the evidence that they have for motive. And they want you and I and the international public to believe that for some reason, this would cause Karen to want to murder John. Remember, okay? John, I'm sure he made a very nice living. He's a Boston police officer for 16 years. I'm sure he made a very nice living. I'm sure he had a pension. I'm sure he had all kinds of things. Karen Read is a very successful woman. She makes her own money. She doesn't need any man to support her. And so a lot of the cases that we look at that involve spouses or significant others or, things such as like this, money is the motive, right? You can't say that here. There's no motive. There's no money. There's no monetary motive for Karen. She made her own money. She probably had a lot more money than John did. She probably had a nice car, beautiful home. They can't use money as their motive because they weren't married. She wasn't the beneficiary of any life insurance, like in the Daybell case, where those two were collecting life insurance policies all over the place. So they don't really have a lot as far as motive goes. They've got the testimony of two children who are going to say that they were fighting all of the time. And for those of you who are married or in a live-in relationship, how often do your kids think you fight? That's a question. And is their perception of adults fighting different than what you and I might consider just a everyday argument? They're going to use some angry voicemails that Karen left John after she got home to show that somehow she had a motive to actually kill him when if she knew she hit him and he was dead, why would she be leaving him angry voicemails? But again, how many of us have left nasty voicemails that we wish we could take back? And maybe one of the carriers, the cell phone carriers, should actually start using that feature or invent that feature where if you send a voicemail, you can retract it within a certain period of time, because I think every single one of us has left some nasty voicemails that we wish we could take back. But they're going to use that. They're going to use the kids' testimony, and they're going to use these two people who were in Aruba and two people who were not in Aruba, including John's brother and his wife, who are going to come in and testify that, Paul Lakeef's wife is going to testify that Karen and John got in an argument the morning before John was murdered because Karen was perhaps being too generous with the children and buying them expensive clothes and gifts. And John didn't want the kids to be spoiled. And also, Karen did like the worst thing you could imagine. She, on the way to school, driving the niece to school, went to Dunkin' Donuts and bought her an iced coffee. And apparently that was a bone of contention for a murder. So, although John was mad about it, not Karen. So this whole thing makes no sense to me. And when I tell you that this is exactly the testimony that you're going to hear, this is exactly the testimony that you're going to hear. There is nothing else there. We've heard about it all. There's nothing they got in their back pocket. The Commonwealth has an obligation to turn over all of their witness statements and all of their discovery. So we know what they have. And that's what they have. Okay? We don't know what the defense has because, unlike the Commonwealth, the defense does not have an obligation to tell the Commonwealth about every single sentence that one of their witnesses is going to testify about. Okay? They gave a list of witnesses. And now the judge is going to say, I'm going to send the state troopers out to interview them. I need their dates of birth and their addresses, and the state troopers are going to go interview them. But what she doesn't say is that these witnesses are not required to talk to the state troopers, number one. And number two, that is really number one. So we don't know exactly what many of these witnesses are going to say, but based on who they are and based on their role in the story, I think we have an idea of what they're going to say. And I think this is going to be perhaps one of the most explosive trials that I have ever watched. I mean, this reminds me of OJ, back in 1995. And OJ actually could not have died at a better time for this case, because everyone remembers, if you watch the OJ trial, which went on for 8 months, by the way. I can't believe that went on for 8 months. And everybody was glued to that. That was when Court TV, I think, really got it. I don't remember how long they had been in existence, but Court TV did go away for a while and then came back just recently. Not recently, a couple of years ago, whatever. OJ's trial was 8 months long. And who doesn't remember Mark Furman and the whole allegation that that cop planted evidence? And OJ was acquitted. So it reminds everybody about this case from 1995. And it makes the allegations here maybe not seem so crazy, because in the beginning of this case, everyone's like, that's crazy. Oh, that's crazy. They've already said they have video of the incident. But they don't. We have the receipts on that because we looked at it. So there's that. Back to the rest of it. See, I go off on a tangent and then I forget even where my place was. Okay. So they said they're going to allow, they're going to see how it goes with the child witnesses, and they're going to allow leading questions if necessary. Then they talked about the references to Turtle Boy, Aiden Carney. So they want to, both sides agreed they did not want anything having to do with a journalist, blogger, Aiden Carney, AKA Turtle Boy, coming into this trial. Neither side wanted it. And the judge said, okay, but that doesn't have to be my decision. And I even think even Lally was like, huh? What do you mean? And she said, well, and she said this again yesterday, if the witnesses bring it up organically, it's coming in. Which to me, and yes, I'm not a criminal defense attorney. I never said I was a criminal defense attorney. So if you think you're bashing me by calling me a civil litigator, game on. Here's the thing. When you go to law school, you learn about everything. And then when you come out, you sort of decide what you want to do. And you could specialize in one thing, or you could do all kinds of things. You could write wills, you could do divorces, you could do DUIs, you could do some personal injury, you could do it all. But if you think being a civil litigator and your little videos that you're making over there is a dig, I've helped injured people and victims and survivors of the most horrific things rebuild their lives for 30 years, and you better bet that I'm proud of it. Okay? And my clients would tell you the same thing. In any event, the judge has said, if the witnesses bring it up organically, it'll come in. Well, yeah, it'll come in because now you've given them almost the permission. What is that they say? Better to beg for forgiveness than ask for permission. So, hey, on TV, I'm just going to tell all you witnesses, yeah, feel free to bring it up. Turtle boy, turtle boy, turtle boy. He was harassing me. Okay. Well, I don't know. We'll see how that goes. I don't agree with that, but okay. I would have preferred witness instruction as telling the witnesses, no, we're not going to bring that up in this trial, just like she's trying to prevent certain other things from coming into the trial. So there's that. Then there is, and I think I have this in my piece here, the redaction of the manner of death on the death certificate. So if we don't have that in the piece that I have pulled up, I'm going to tell you that there was some confusion I saw in the chat and comments about that. So here's the thing. On the death certificate, the manner of death is undetermined. That is what the medical examiner put on the death certificate. There are 5 manners of death that you can choose from. It is homicide, suicide, accidental, natural, or undetermined. This medical examiner has undetermined as the manner of death. As far as I know, the death certificate has never been amended, so it still says undetermined. The judge's ruling was that the medical examiner can be cross-examined about the manner of death, and that's how the defense is going to get it in. But she's redacting it from the death certificate that the jury is going to bring into the jury room. That's all. Don't worry about that. They're allowed to talk about it on cross. So isn't it true, doctor, that you were unable to determine the manner of death for Officer O'Keefe? Well, yeah, that's true. But on the physical death certificate that the jury is going to bring into the jury room as an exhibit, it's going to be redacted. It's really not a big whoop. Don't worry about it. Don't worry about it. Okay. All right. So let's, I don't know where I have it pulled up here, but I'm sure we'll figure it out. All right. Let me know that you can hear this. I don't think you're going to need closed captionings on this. If you do, just let me know and I'll put them on.
Allowing 45 minutes for the Commonwealth?
Yeah, sure.
Okay.
All right. So she's allowing 45 minutes for openings. I don't like it when they time openings, but she's keeping a tight rein on this circus. She's keeping a tight lid on this, tight tent on this circus. All right, here we go.
Okay. All right. And Commonwealth, do you intend to put anything up during openings?
During openings, no, Your Honor.
All right. Okay. Commonwealth's motion eliminate for notice and voir dire of Bowden. I thought that was, we decided that there would be a voir dire regarding before the Bowden testimony comes in.
All right, let me talk quickly. Yeah, sorry to actually Sorry to actually interrupt this right away, but a Bowdoin defense in Massachusetts is a defense that the investigation was shoddy, basically. That's what it's saying. That the investigation was inadequate. And the case is Commonwealth v. Bowdoin. And so here's just a little synopsis of that. Inadequate police investigations where police fail to take reasonable investigatory steps are one of the leading causes of wrongful convictions. Frequently, due to the difficulties criminal defendants and their attorneys face in conducting their own investigations, a defendant's best course of action when faced with a faulty investigation is to point out the deficiencies of the investigation during trial. As a result, this defense has been recognized by the Supreme Court as a common trial tactic of lawyers. However, despite the Supreme Court's acknowledgement of the defense, many federal jurisdictions bar the defense on grounds of relevance. Okay, so I guess this is a Supreme Court case, not a Massachusetts case. I was wrong. So the judge has some discretion when allowing certain evidence in, but basically that is what Bowdoin is. That is to be contrasted with the third-party culprit defense that they're also talking about here, where the defense in certain cases, or in any case really, can point the finger at a third-party culprit and say, she didn't do it, they did it, or he did it. But they don't have to be specific about exactly who that was. They just have to show that it could have happened in some other way. So hopefully that makes a little bit more sense for you. She's talking right now about the Bowdoin defense, or the inadequate investigation defense.
I don't recall that, Your Honor.
All right. Well, Commonwealth's entitled to a voir dire. There'll be a voir dire.
My understanding of the court's ruling, as it applies to opening statements, is that I cannot point the finger at a third-party culprit, but I can introduce the idea of an inadequate investigation and discuss Bowdoin evidence.
As long as you know it's coming into evidence.
That's perfectly fair.
Remember, I use that term competent evidence.
Remember, I use that term competent evidence because, you know, I mean, it's very school teachery. Her, yeah, the laugh was, I thought the laugh was disrespectful, Kate, too. I did pick up on that on that laugh. So he's allowed to open on inadequate investigation, which is great. Can't wait. Can't wait to hear it. I'm here for it. Monday morning, we are here. We are locked down 10 a.m. We are going to go through this together. We're going to sit through it together. We're going to watch it together. We're going to talk about it in the chat. And he's going to be able to open on the inadequate police investigation. And that's huge. And it's fine. That's cool. Don't let him talk about the third-party culprit in the opening, because all that stuff will come out during trial and he'll be able to close on that masterfully. So Mr. Yannetti's going to do the opening, and I don't know, maybe Alan Jackson will do the closing. I'm not sure, but I think that's a great decision.
That's what it has to be.
Of course.
All right. Sorry, Jim. 321, the Commonwealth's bolded 31, in case my number's not right.
Thank you.
319. So this is, we talked a little bit about this. It's Commonwealth's motion for advance notice if defendant intends to cross-examine any witness about alleged bias, and request for pretrial ruling on whether the proposed evidence demonstrates a plausible showing of alleged bias. So as you well know, Mr. Lally, bias is definitely an area that is ripe for cross-examination and extensive cross-examination. I needed to know exactly what your concerns are.
And, Your Honor, I think what I would suggest
Can you get the camera off Karen? Can you get the camera? Because everyone who thinks Karen's guilty, everyone who is convinced Karen's guilty is convinced that Karen is guilty because they don't like her facial expressions. Because they don't like her facial expressions. They think she's smug. They think she smirks too much. And now apparently her clothes are too expensive and her skirt yesterday was too short. And you know what? I noticed that she's been wearing pants the entire time. And I thought to myself, I wonder why she's not wearing skirts. And you know what? After she was attacked yesterday for wearing a skirt, or the day before, makes a lot more sense to me now. Disgusting.
might make the most sense with this is to sort of take it as it comes.
Okay.
I think it's a little difficult to put counsel in a position to, cite specific things that they wish and then,
We have a couple of motions where we do need to do that.
right.
But for generally with this, and because this was broad, that's why I did want to, when we had a brief hearing on this, I said that I did need to hear from you regarding specific statements. So what we're going to endorse this, Mr. Clerk, is that Commonwealth will object on a question by question basis. Does that work, Mr. Lally?
Yes, Your Honor.
Does that work for the defense, Mr. Yannetti?
For sure.
Okay.
Commonwealth
Commonwealth will object to specific questions.
Thank you.
Yeah, something else she said, which I thought was really weird at the end. She said, when there are objections, you are not to state the grounds for your objection. You are going to object and we are going to go to sidebar. That's unusual where I come from because most judges want to hear, most judges want to hear the reason for your objection. Some of them will actually, if you say objection, they will look at you and wait for you to state your grounds for your objection. And some lawyers will just say objection, relevance, badgering, or, like they'll go through a list of 5, hearsay, all of them. It's just as a catch-all, but she does not want grounds for objections, which I thought, any other lawyers in the chat, tell me if in your jurisdiction, that's the way they do it.
And Mr. Lally, if you know in advance, depending on how the testimony comes in, if a particular witness gets up and you know before any examination what your concerns are, we'll visit it before the testimony.
Understood.
Okay.
Thank you, Your Honor.
A similar motion to the defense expert issue. Mr. Clerk, I believe it's 315. It's bolded number 25 from the Commonwealth. Commonwealth's motion eliminate to prohibit defense experts from testifying regarding scientific studies or anecdotal experienced and request for voir dire. Mr. Jackson, do any of your witnesses intend to give anecdotal experiences?
I said this in the argument. I don't really know what that means.
It's like almost the most ridiculous motion I've ever heard. Anecdotal experience. One time when I was in band camp.
But no, in terms of just the common sense knowledge of common sense definition of what that is, to my knowledge, they're not going to be talking about any.
Okay, I think it's pretty clear what it is. But if you think they're not going to do it, if it seems that they are, then we need to know. And how about the scientific studies?
The scientific studies would not be referred to in any of their testimony that I'm going to elicit at all.
Okay.
They did some scientific studying of the material.
No, do you mean like learned treatises and things like that, Mr. Lally?
Exactly, Your Honor.
Yes.
They're not going to be citing to learned treatises that I'm going to elicit.
Okay.
Learned
All right,
treatises.
that's it in my category of discovery. There's some overlap in the motions that I think the following motions may take a little bit more time, and it's sort of the somewhat complex ones. So 311, Commonwealth's bold number 21. Commonwealth's motion eliminate to admit the victim's out-of-court statements relating to his state of mind. There's sort of some overlap, Mr. Lally, that we'll get into with other statements. But so this is the Commonwealth versus Qualls, Commonwealth versus Bins, that whole line of cases. Why don't I hear you? Is there any objection to this?
We may have a moment, Judge.
The Commonwealth, we were here last, the Commonwealth was told that they need to provide with the statements or the areas they intend to introduce. They do so in this motion. They do more extensively in another motion that's sort of dovetails. And the other motion concerns the Aruba incident, the arguments between the defendant and Mr. O'Keefe, and also this Bin/Qualls type testimony.
Right, so I think
I'm just going to break for a second. Chrissy Painter's daughter says, I noticed that, and only one attorney can give the objections. And that's totally normal because you can't have 3 attorneys standing up and saying objection. So whoever is questioning that witness, it will be their objection to make. So when they go to sidebar, that attorney who is questioning that witness will be the one to argue the objection. They can all come up to the sidebar, but one attorney will argue the objection. I think they can all come up to the sidebar unless she's only saying that only the attorney questioning can come to the sidebar. But that's got to be the one arguing, and it's fine. That's cool. I mean, that's typical.
Our position, Your Honor, was that we need to know the specifics of what they intend to introduce. My expectation is that some of that will be admissible and some of it we won't have an objection to, but it's difficult to give either a blanket objection or a blanket assent without knowing the specifics.
Okay, but you did sort of make a blanket objection to the Aruba incident, if we
But
call
we
it
had,
that.
we had to without knowing the specifics.
So on the second page of this motion, the Commonwealth intends to introduce statements the victim made to his family members and friends close in time to the murder about his relationship with the defendant and his decision.
Close in time to the murder. Okay, so you tell me if you think this is close in time to the murder. It was New Year's Eve. The murder was on January 22nd. So 22 days. Do you think that's close in time to the murder? Tell me what you think. Yes or no?
To terminate the relationship. The Commonwealth also intends to introduce the victim's statements through text messages authored by the victim and contained within the victim's cell phone that express his decision communicated directly to the defendant to terminate their relationship.
Okay, I got to take that back because apparently that she wasn't talking about Aruba and saying it was close in time. She's talking about text messages and I guess the witness testimony of the children.
That goes squarely with Qualls and Bins.
Right. With regard to the text messages, I don't believe we have a basis to object.
All right. So I'm also going to allow statement. Mr. Lally, tell us what the statements specifically, as best you can. Who would be testifying? What family members? Does this involve the two children?
Yes, Your Honor. So there are statements that are made by the victim to the defendant in front of each of the two children with his intention to.
What are they roughly?
Essentially that the relationship isn't working anymore and that he would like to break up with her, ask her to leave the house. She refuses, and this is in front of both the niece and the nephew.
Who were at the time, if they're 16 and 13 now, they were 13 and 10 or 11. Okay.
All right. Ms. Giannetti, I'll hear you on that.
Somebody said in the chat that they thought that this hearing showed how unprepared the defense was, and I couldn't disagree with you more. I think that some of these issues were so far out of left field and so Twilight Zone-ish that they're just thinking like, what? Like, why would you have to argue this? But I disagree. I think they are very, very prepared.
Our expectation is any statements that were allegedly made by Mr. O'Keefe to my client in front of other witnesses, we don't have a basis to object to that.
Okay, so that's coming in, and you've had the benefit of the SANE interviews for a long time.
Correct.
Right, so
We don't waive potential hearsay objections during trial, Your Honor, but I think generally that's our answer.
all right, so on 311, Mr. Clerk, I'm going to allow that.
Yes, Your Honor.
I have a question. I have a question to my Massachusetts friends in the chat. They keep referring to these SANE interviews, which were held at, and if anybody can explain to me why they keep referring to them as SANE interviews, because my understanding is that SANE interviews have to do with SA or DV, and from what I know about this case, neither one of those things are at issue here. So is that just where the children were interviewed because they did not have qualified investigators to interview the children? I have questions about that. So if anybody really knows the answer to that question, let me know. Okay, right, Michelle, exactly. SANE in Massachusetts, it's SA nurse examiner. So why, yeah, the DV was mentioned. We're going to talk about that as well. So I don't understand why. The judge keeps bringing it up. She does. I know. Okay. So I'm wondering, nothing is seen here. Lady Di, making me laugh for the second time with your comment. in the chat. Oh, thank you, Olivia. Yes, Melanie saying is for SA Intervention Network. There's just certain things we can't say on YouTube, or they'll just strike the stream and shadow ban us. I don't know why they're saying interviews. I know. I don't know why either. I have questions. Kids are only interviewed by SANE. Okay, so it has nothing to do. It doesn't have to be. There don't have to be allegations of SA or DV in order for children to give interviews in any type of criminal case as witnesses. So, Chief Sherry, thank you. SANE interviews are for SA nurse examiner, right? But somebody's saying that for all children child interviews. So I don't know. Thank you. That makes sense, Aaron. They specialize in trauma.
All right, so sort of the same. 310.
Olivia, if you can chime in on this question, weren't the children interviewed months after his death? I don't remember the exact date of the child interviews, but I am sure that you do.
And the defendants is 283. It's a similar motion. So, Mr. Lally, why don't I hear you on this? So this is the one when I said there are 3 areas here as I see it. If we call it the Aruba incident, the animosity between the defendant and the victim in weeks and days prior to the victim's death, and that the defendant admitted to numerous witnesses at different times that the last thing she recalls was getting into an argument with the victim. So that whole domestic violence line of cases.
There she goes. Domestic violence line of cases. Like, really? Why do you have to refer to them as the domestic violence line of cases? Because you're on television and you want to put that in the back of everyone's head? Are they pursuing a theory of domestic violence? Because I've read the Commonwealth's theory of the case as it kept changing. I think we went over together at least 3 or 4 theories of the case, none of which involved any allegations of domestic violence. So why are we putting that out there, Judge? Couldn't you just say, whatever, McFarland and Graham? Can't you just name the cases, or do you have to just say domestic violence cases? I don't know.
Clearly is admissible. So why don't I start with you, Mr. Lally? Go ahead and argue your motion.
So, Your Honor, specifically, what the Commonwealth is seeking to introduce there is you have the incident in Aruba, which there are really 4 witnesses who have information to provide to the jury.
Do we need all 4?
Do we need all 4? Because you know what? 2 of them weren't even there. 2 of them were in Aruba. One of them is going to testify about what her sister told her about the argument in the lobby, which the judge is then going to call an altercation, by the way. But 2 of those people were not even in Aruba. It's like double, triple hearsay.
Well, so from different perspectives is what I would say. So 2 of them are, the incident or altercation occurs in the lobby of the hotel where the defendant, the victim, and the children are staying along with a larger party of friends of the victim. Following that incident, both children indicate that there's approximately a 20-minute screaming match or something to that effect.
Both children were present?
Yes, within the hotel room, and both indicate to that. Then you have the woman, Marietta Sullivan, who's involved in the incident in the lobby, and then you have her sister, who is the person who invited them on the trip in the first place.
There's some additional testimony from these witnesses too, other than just the statements?
Correct. So the additional testimony from the sister who invited them on the trip, she's not a recipient witness to the altercation. I wouldn't be asking her anything about that.
Okay.
What I would be asking her about is just her observation. So she had gone out the evening prior with the victim and the defendant to dinner, and sort of the
Karen picked up the tab for that dinner, by the way. I think there was something like at least 10 people at that dinner. Do you guys remember that somewhere? Olivia, maybe you know? Karen picked up the tab. By all accounts, she's a very generous woman. But let's hear what the Sullivan sister has to say about her perceptions of Karen.
The disparity between sort of their demeanor on the night before versus post this incident. And there was some statements that Mr. O'Keefe made to her about sort of the nature of their relationship or the nature of his relationship with the defendant.
I'm sorry, but you can't cross-examine a dead man. You can't. And you know when these witnesses were interviewed, my friends? They were interviewed before the children, that's for sure. These Aruba witnesses were interviewed on February 7th of 2022. That came out recently. So the state, the Commonwealth, was more interested in tracking down people who have trash talk things to say about Karen than they were talking to actual witnesses who might have been in the house when Officer O'Keefe never came inside. But
And those statements have been provided to the defendant?
Yes, Your Honor.
There was testimony in the grand jury regarding those statements?
There is, yes. There's state police reports as well as testimony from the witness and the grand jury.
Okay.
In addition to that, as far as statements relative to the nature of the relationship, there are some minimal statements that are made by the defendant to a couple of witnesses at the waterfall the night before. Again, those are also contained within troopers' reports and the grand jury testimony of those witnesses. There are also the text messages between the victim, Mr. O'Keefe, and the defendant, which specifically address the nature of their relationship. There are text messages from the defendant to Mr. Higgins, which again specifically address not only the Aruba incidents weeks later, as well as and being a continuing point of concern, at least from the defendant's perspective, as to the nature of their relationship.
yeah, the Dunkin' Donuts was the trigger. Dunkin' Donuts and nice clothes. That's the trigger. Don't spoil the kids.
And then taking all of that sort of in conjunction with the text messages between the two that day and the voicemails messages that the defendant left on the victim's cell phone shortly after the murder occurs. And then there are further statements that the defendant makes to a number of different people, whether they be troopers, whether it be paramedics, whether they be Ms. McCabe and Ms. Roberts, or in the presence of them, as well as at least 3 paramedics, indicating that the last time that she saw the victim, Mr. O'Keefe, they had gotten into an argument essentially at the house at Fairview Road right before she had left. So those are sort of the totality of the sort of specific areas in the nature of the relationship that the Commonwealth will be seeking to explore through the testimony of a number of different witnesses.
Okay. Who's arguing this for the defense?
I will, Judge.
Okay, so the children, Olivia says they were probably not interviewed somewhere around February 21st, right? So they interviewed all of these witnesses from Aruba before they ever interviewed the children. And they did not interview the snowplow driver, Lucky, who plowed the street that night. And then one time he couldn't plow the street that night because there was a Ford Edge parked in front of the house at around, correct me if I'm wrong, between 3 and 4 a.m. So he couldn't plow at that time. But they didn't look for him. They didn't interview him. And not until like 18 months later. So you can see where they were going with this, what the priorities were in this investigation of a dead Boston police officer. In New York, heaven and earth is moved when a police officer dies, whether it's on the job or not. It wasn't done here. It wasn't done here. The investigation, if you don't know a lot about this case, when you hear about what happened during this investigation, it is going to make your blood boil. Oh my goodness, Stacy. Thank you for the incredibly, incredibly generous donation. I appreciate you guys so much.
As I'm listening, there seems to be quite a few different categories of information that the Commonwealth is seeking to introduce, and through different means. So, it's difficult to, again, just give one blanket objection or one blanket assent to this. Generally speaking, witnesses who would testify about statements of Mr. O'Keefe's state of mind, that probably comes in.
We talked a little bit about that. That's the quals and the
Correct.
bins line of cases. So
Correct.
I did rule that those are coming in.
We recognize that,
Okay.
yes.
You said probably.
Well, yes. Well,
So catty. So catty. I mean, it's just like, and then at one point she says to him, well, you've never practiced in my courtroom before. You've never been in front of me before. I mean, it's like teacher's pet. Somebody said that earlier. It's like teacher's pet. Mr. Lally, let me help you. Let me throw you some softballs. If you're having trouble getting your words, I'll give you the case and say, oh, isn't this the case that you wanted to refer to? But forget it. That's why Alan Jackson's not even getting up, because he's like, listen, every time I get up, she trashes me for being from California. This is the way we do it in Massachusetts. We stand up in Massachusetts. Those of you who know, we've watched these hearings. This is not typical that it's this obvious. Sometimes you can get a feel for which way the judge is leaning, but it in my opinion, it is very obvious here that she does not like the defense.
Mr.
right.
Lally raised it again, so.
And you don't have to assent. You can object to anything you want to object to, and I make the call. I mean, so you don't need to point out, you don't need to apologize for objecting. Just go ahead and tell me the defendant's position.
Right, I understand, Judge. I think the position here is that we recognize that much of this will come in, but we don't waive the ability to object to a specific question in terms of what it's, what it asks for, how it's phrased, what could potentially come in if the question's too vague. So that's my hesitation on not.
So that's well taken. So even if you assent to it, doesn't mean that if a question crosses the line, you're prohibited from objecting to it. I've never done that before.
That's my point.
Yeah. So you haven't tried before me before. I would not do that.
You haven't tried before me before. There it is. I thought we missed it.
So I find that, let's say for the Aruba statement, all of these go to state of mind and motive. I will give a limiting instruction. I will make the findings that I need to find pursuant to Kamala versus Samir. It's a footnote in that case. It's footnote 8, I believe. I will make those findings at the time. There's certainly been a sufficient showing from the Commonwealth.
State of mind and motive is the only thing she's going to allow that testimony to go to. And she's going to tell the jury, please, jury, you can only use this testimony to consider state of mind and motive. That's it. You can't use it for any other purpose. And, in her mind, that a limiting instruction is going to be fine. And she can have 4 witnesses come in and testify about Aruba when only 2 of them were there.
So I will give a limiting instruction. I will welcome proposed limiting instructions if you want to file them. I know you're all busy. If you don't want to, that's fine. I can handle that. Regarding the animosity, again, it's close in time. It goes to the nature of the relationship. I will give a limiting instruction. I'm confident that the limiting instructions will be followed by the jurors, that they're understandable. I will make observations at the time, and if they're appear to be understanding and nodding, which you often see on limiting instructions, I will make those findings as well. But I'm satisfied that the jurors will be able to understand a limiting instruction and use the testimony only for the intended purpose.
You're satisfied that the juries are going to be able to understand a limiting instruction? Are you satisfied that now that you've broadcast to the general public, including every witness that's going to come in and testify in this trial, that it's okay if they bring up organically Turtle Boy? I don't know, you guys. This is just whack.
And the animosity goes to the nature of the relationship, goes to the domestic violence line of cases. And the argument being the last thing that the defendant says she recalled, and the children's testimony regarding ending the relationship, again, that goes to state of mind, and it goes to the quals and bins line of cases. And I will give a limiting instruction. I'm confident the jurors will understand. So that's my ruling on that, which actually, so it would be a denial, Jim, of defendant's motion 283.
Just for the record, it's 282.
82. And that's denied. I mean, it will not go to propensity, and we can make sure of that. And the Commonwealth's motion is 310, Jim, the bold 20, and that was sort of hand in hand with the other one. All right. So moving on to, I think we just briefly talked about, so it's paper number 306, Commonwealth's motion in limine to admit expert celebrate demonstration. I think we briefly talked about it, and I wanted to know, so are the defendants objecting to the, so your witness's name again, I read it every day for the
Whiffen.
last week.
Mr.
It's okay.
Whiffen.
It's Mr. Ian Whiffen.
Yes. So about him doing a demonstration, is there an objection to that from the defense?
Do people think that they're unprepared because they're whispering about the best way to approach this? Listen, when you are in the courtroom and the judge is making her rulings, you got to think on your feet. Just because you don't jump up and start arguing right away before you start speaking doesn't make you unprepared. So that's my opinion.
Your Honor, thank you. Since the last time we were in court, we've had an opportunity to look at that.
Yeah, I'd like to look at it, but okay, so you looked at it?
We did. It's not that long. It's maybe, I don't know, I want to say 22, 25 minutes, something like that. We'll submit on the papers and stand on the objection that we previously made, that it doesn't comport with the exactitude that we think is necessary for a demonstration, but I don't think it bears. It's not an enormous deal for us. We do stand on the objection, but I'll submit on the papers.
All right, so I'm going to allow it, but Mr. Lally, I'd also like to see it.
Of course.
Okay, so if you could get me a copy, Ms. Gilman, can you get me a copy of that before the end of today?
I think so. Yes.
All right. Thank
Speaking
you.
for.
That was
All
I
right.
forgot.
All right,
That
so
was
Jim, 306 is
Ian Whiffen. They want to interview a PowerPoint presentation in case he's unable to, I don't know, explain, or in case there's like a, his has to do with, I think, the Celebrite extraction. Was that him, Whiffen? Somebody can chime in on that, but apparently he wants a PowerPoint presentation in the event that, I thought there was a contingency on that. The tech didn't work or something. I don't know. But apparently the defense is like, whatever. You let him have his PowerPoint. We don't care. You got to pick your battles here. You got to pick your battles. There are some things worth fighting for and other things that are not going to hurt you. Just like, whatever. And there are certain things, in my opinion, that are going to make the prosecution look really bad. Like, I cannot believe they wanted that June 20 of 22 video of Karen in the precinct saying, you're all in on the same joke, right? You know that Colin Albert and Brian Albert beat him to death. My taillight was cracked and John's was pulverized. They want that in evidence, because what that does in my mind is show that Karen knew as early as 4 months post her first arrest that that's what happened. So everyone's saying, oh, they didn't even decide to use that theory until Alan Jackson became involved in this case. No, he became involved in that case, I believe, after that. So I don't know. I think that makes the Commonwealth look bad, but hey, they're the ones who want it in, and they're going to say it can come in, but audio only, because the video was body cam footage from the officer's body that really only showed his computer screen. So it was a little bit distracting, and you can't see Karen at all.
is allowed.
Thank you.
All right, so the two that may take, there's three actually, but the two that we'll cover here before we get to sort of logistics and sequestration. Commonwealth's motion to prohibit reference to any pending internal affairs investigations or unfounded allegations. And I did just, I don't know why, I know you filed it previously, Ms. Little, but I just today had the opportunity to read your supplemental memo in opposition. Okay, so, all right, so this is twofold. So I'll hear the Commonwealth regarding Trooper Proctor and also regarding Sergeant Lang.
Sure.
For those of you who are just joining and may just be getting into this case right now, let's take a short break and go to the chat for a moment, see how you guys are doing. But Trooper Proctor is the lead investigator of this case from the Massachusetts State Police. He is also under investigation by Internal Affairs because of his handling of this case. And there is a federal investigation of the Karen Reed murder case going on right now by the FBI and the feds. So many, if not all of the witnesses in this case for the Commonwealth have testified in front of a federal grand jury as well. And during the federal grand jury, Michael Proctor, the lead investigator, admitted to the federal grand jury that he hid the fact that he had close personal ties to many of the people involved in this case, including the Albert family who owned the home on which Officer O'Keefe's body was found. Sergeant Lank, who was from the Canton Police Department, was one of the first responding officers to come from the Canton PD after the 911 call was made at 6:04 a.m. Sergeant Lank also has a long history of inserting himself into cases involving the Albert family, and they will talk about that a little. And when they start to talk about that, I will come back and tell you what happened, why he was sued back in 2002 for an event that occurred in 2002. And what happened there when he came out to insert himself into a case involving Brian Albert's brother. So thank you, C. Morales, for becoming a new member. You are awesome. Young Black economist, thank you for becoming a member for a month and love it. In for the smart takes. Thank you so very much. Mike Dorado, thanks for the super chat. We are the point, dear. You are. Lisa, thanks for being a member for 2 months. We lift each other up here. Okay. Oh, that's a good soundbite for one of my haters. Awesome. Mandolin Wynn, thank you for your super chat. Right on, sister. And your hair looks amazing. Thank you. Thanks. My skirt's a little too short, but I'm sitting at a desk so you can't see it. JK, I have sweatpants on. Casey, thanks so much for the $5 super chat. My daughter graduated from the State Police Academy, 9th in her class. Congratulations. This is applause in ASL. That's amazing. Congratulations to your daughter. That is awesome. She ain't no token. I appreciate you so much. Thank you. Thank you, Casey. And thank your daughter for becoming a woman in blue. That makes me very proud. Even though I don't know your daughter, I feel very proud anyway. So congratulations. NDF, thanks for the super chat. Where can we find the stream of you and Brandy? Not on her page. Yeah, it's on my page. And I think in the title, it says Brandy Churchwell joins. So you can go back and watch that later. Thanks. And by the way, you are on a totally different level than that form. She has no class and no clue. You're not talking about Brandy, I know, in that tweet. But I mean, in that tweet. See, you got me on because I know what you're talking about. Thank you. Thank you, Lori, so much for gifting 5 memberships. And to the random people who were awarded them, welcome. Camille's Rando fan, thank you for your super chat. On your way to making $1 billion, you're welcome. Oh my gosh, thank you so much. Thank you so much. Renee, thanks for your super chat. Can we vote to start calling Judge Breathy Path? It's accurate, yes or no? Yeah, somebody said on Twitter, like people send me things all the time because I hate it and I'm not on it, but you guys keep me laughing. They're like, you are so rude to comment on the judge's breathing. Okay, if you hear heavy breathing during this stream, it is not me. The judge is breathing. Look, she's really close to that mic. Maybe she should just move the mic away a little bit. I'm just saying. It is breathy paths. Reminds me of like 1-800. Cindy, thank you for being a member for a month. Love your show. Hope you make it to Dedham. If somebody else gets out of Dedham, maybe I will. Della, thank you so much for the super chat. Where is the FBI who said no to this? They did. They said, we cannot in good conscience allow this case to go to trial. That's what Josh Levy said. Jury has not yet been sworn. Jeopardy has not yet attached. Stay tuned. I don't know. We'll see. Auntie Shell's Kitchen, thank you so much for your super chat. Hi, Melanie. Sorry for being out of the loop, but what does Aruba have to do with the death of John O'Keefe? Well, on New Year's Eve, they went on a trip to Aruba with something like 50 people, I think. And they were invited to go with these people called the Sullivans. And the Commonwealth is trying to say that because of an incident that happened when John came out of the elevator, he hugged a woman who, her name is Marietta Sullivan. She's going to testify that Karen said, who the F is that? and that he said, that's so-and-so's sister. And she said, F you to the woman. The woman said, F you back. And then her sister, whose name escapes me right now, but her name's also Sullivan, is going to testify that she thought Karen was an a-hole because she wanted her own bathroom in Aruba and she rubbed her the wrong way. And that they're going to somehow try and show that this was motive for murder, you guys. Suzanne, thanks for your super chat. It's Sane, S-A-I-N, not S-A-N-E. Family Service Advocate. She works to meet the needs of the child victim and their family during the SANE. Yeah, but I just didn't know if it was limited to cases of SA or DV, or if it was they interview all children. Thanks, Mace, for your super chat. Thank you, Melanie. This case needs your perspective. Thank you. Sometimes I feel like I'm out here on an island all by myself with all of you, though. I mean, if I'm going to be stranded on a desert island, you're the guys I want to be with. So thank you. I have questions. Oh, good. I started this myself. They use SANE to reduce the number of interviews. That way, it's just the one interview. Says, I have questions, and that makes perfect sense. Thank you. Michelle says, the SANE team follows a model approach to CA intervention and investigation. The children are interviewed in a non-leading manner by a trained forensic interviewer in a child-friendly environment. Thank you so very much. We will come back to you guys later. I'm going to leave it right there for now. Let's go back. Let's go back to the hearing.
Your Honor, with regard to, I think the recent sort of progeny of cases between McFarland and Graham are sort of entirely instructive. I would submit as far as this particular area is concerned. So when it comes to Sergeant Lank, you're talking about a civil case with no judgment. There was no finding. There was no trial.
Okay. Since I am a civil litigator, I'm going to tell you what that means. That means that two men sued the town of Canton and the Canton PD, and Sergeant Lank, I believe, was also a named defendant in an assault case. There was no judgment in that case because they settled the case. Doesn't mean there was no liability or deposition testimony given in that case. Canton, PD, and all of the defendants collectively settled the case for hundreds of thousands of dollars. So it's a little disingenuous because I'm sure there's deposition testimony of Sergeant Lank, who was a defendant in the case. And there's also testimony by the plaintiffs in that case, the Lapolito brothers, who are on the witness list.
So I think Graham and McFarland are pretty clear that is not conduct that can be used in a criminal case to impeach a
But
witness.
why can't it be used regarding, I think what separates this in some respects from those cases, even though there's no finding, is just like the pure bias part of it, right? If there's bias in favor of the Alberts, which is what the defendants say their defense is among the possible third-party culprits, why can't they cross-examine on that?
Well, the information that I've seen, I don't think specifically lends to a defense of the Alberts. I think if it lends to anything, it lends to.
Have you been paying attention? My eye just started to twitch. Their defense doesn't lend to the Alberts. It happened on their front lawn. Brian Albert and Colin Albert were mentioned in the video that you're going to show the jury, where Karen says when she's in custody, because by the way, you went and arrested her after the grand jury indictment on murder charges and hauled her in there in cuffs instead of calling her attorney as a courtesy and saying, can you bring your client in? You want to show that video to the jury. It's coming into evidence where she names them as being the ones who beat him to death, and now they're not involved? How is the gallery not bursting out laughing right now? I just got to rewind that a second because it deserves to be heard again. Again, I'm in the Twilight Zone. Somebody put some Twilight Zone emojis in the chat.
some respects from those cases, even though there's no finding. It's just like the pure bias part of it, right? If there's bias in favor of the Alberts, which is what the defendants say their defense is among the possible third-party culprits, why can't they cross-examine on that?
Well, the information that I've seen, I don't think specifically lends to a defense of the Alberts. I think if it lends to anything, it lends to Sergeant Lank being involved in some sort of altercation himself, and whatever extent there's any veracity to whatever is alleged by the other parties to have occurred. Firstly. Secondly, I don't even believe, again, I think we're going to, one Albert equals the entire Albert family kind of thing. And I don't think that any of the Alberts that they point to, or at least that Mr. Yannetti got up and spoke about being potential third-party culprit targets, were even present, involved, or had anything to do with this prior incident.
This is where I lost my mind. And I'm twitching again. There are 6 Albert brothers. They've lived in Canton for generations. They all went to high school together. People from my friends, you've sent me emails that some of your children went to high school with them, and many of your sons looked up to the Albert brothers. They were idolized in many ways. What did she just say about, like, this can't even relate to the whole entire Albert family? Do you guys?
I think we're going to, one Albert equals the entire Albert family kind of thing. And I don't think that any of the Alberts that they point to, or at least that Mr. Yannetti got up and spoke about being potential third-party culprit targets, were even present, involved, or had anything to do with this prior incident. So whether or not Sergeant Lake knows or was 20 some odd years ago friendly with one member of the Albert family, or even 2, if they're not any people that were at the residence on Fairview Road that night, that were present there in the morning when he arrived, pursuant to a call from a sergeant on scene to investigate, or anything of that like, I don't see how it's relevant to that form of questioning or impeachment.
Oh, it's relevant.
Particularly where it's an unsustained finding and there's nothing, concrete as to what transpired.
Okay, I guess my question was simply because something might not fit squarely in McFarland and Graham. If it's admissible for other purposes, then it can come in. Right. So who's arguing this part? We'll take these in 2 parts. So we'll do the Trooper Proctor part afterwards. But there's I did say I'd give you the opportunity to argue those 2 cases, but if you want to, you can. But I'm more focused on the bias or motive.
Sure. I'll just briefly address Graham and McFarland, because
sure.
I do think it's very important that we make clear that both of those cases are completely an opposite to the issue that's before this court, which is admissibility at trial. McFarland and Graham both deal with whether the Commonwealth has an obligation to turn over certain discovery. That's not where we are right now, right? We filed the appropriate motion to receive discovery. We obtained information about an IA investigation. We obviously
let's focus on Lank first.
Sure.
Okay. So, I agree with you. They're discovery cases. They're not admissibility cases.
Okay. So
why'd you
that
bring them
issue
up?
aside, Lank has he's one of the first responders, obviously, who went to 34 Fairview on the morning of January 29th. He's the first person to enter the Albert residence that morning. And he
doesn't search the residence either. He doesn't search the residence, see if the drinking glass they found outside might match a drinking glass from inside the house. He is the only officer, one of them. I think there's only 2 officers that go inside. One of them is Lank. I forget who his cohort was. I don't remember if he went in alone, but he interviewed the witnesses in a group.
a long-standing relationship with the Albert family, which is brought in by this sort of prior lawsuit that we brought to the courts.
The Albert family appears to be huge, right?
Well,
or very extended family.
Well, I'm getting there. So
okay.
The altercation that Lank was involved in was after he deputized himself to involve himself in a fight that Chris Albert had been in. Chris Albert is one of the Commonwealth's witnesses in this case. He is Brian Albert's brother. He was with them all that night on the 28th. His son, Colin Albert, as you know, is a third-party culprit. So this is not some tangential family member. This is
Who would you intend to, if I allow this, and we really need to see how things develop beforehand. So, Mr. Yannetti, I can tell you right now, I'm not going to allow you to open on this because I need to see how the evidence comes in.
It's not part of my opening.
Okay. Who would you intend? I see you have the Lapalito brothers on the witness list. I think that goes far further than I would allow. But
Yeah, unless they're needed for impeachment. Unless Lank gets up there and you know, minimizes the beating. We'll see.
who do you intend to get the testimony in through and how?
through Sergeant Lank himself. I think we
Okay.
need to be afforded the ability to cross-examine him. Once that's done, we may need the
If he
local
denies
audits to-
it, and we'll
Exactly.
figure that out.
But I think the first step is allowing us to inquire as to his relationships and the connection that he has to the family and this incident that occurred.
so you can certainly inquire as to his relationship with the family. It's the incident. I need to see again, just reading of everything that I've read, Sergeant Lank doesn't have his testimony isn't as lengthy as other witnesses, right?
I don't think that that's necessarily true, Your Honor, as far as our
Mr. Lally said,
cross-examination.
okay, but for his direct is not as lengthy as other witnesses.
I think that's fair to say.
Yeah. So, all right. So
It's direct isn't. But and their cross is limited to direct. That's fine. But they can call him again in their case in chief, and you can bet they will because Mr. Lally is gonna keep his cross as narrowly tailored as possible. It's gonna be interesting.
go ahead. So through him, through Chris Albert.
Through him, potentially through Chris Albert as well, Your Honor.
Okay. All right. So Mr. Yannetti's not going to open on this, and he said he wasn't planning on it anyway. So
No, Your Honor.
let's see how the evidence develops. It may be that we have a voir dire of Sergeant Lank and Chris Albert beforehand. Okay. So
When they say that, a voir dire of the witness, it's basically just like an offer of proof outside the presence of the jury to what they're going to testify to. So, I mean, it's coming in. I don't see how it can't, but and nothing surprises me in the day to day in this case. So we're going to see.
I'm not going to take any action on this right now,
Okay.
but I'm not denying it as the Commonwealth's requesting me to do.
Thank you, Your
So
Honor.
we'll see where we go with this. Okay. All right. So now let's deal with the Trooper Proctor part.
So, Trooper Proctor, Your Honor, in regard to NEI investigation, which we have not received any material in regard to other than its existence. And I want to be clear on that because I think counsel might be a little confused by some material that we provided to them.
Oh, no, they're not confused. I don't think they're confused at all. In case you didn't hear what he said, he tried to rush right through it, but he's talking about the IA investigation, the internal affairs investigation of Trooper Michael Proctor, who's the lead investigator on this case. But we noticed that one of the last hearings or one of the last documents that we looked at from court, they started all of a sudden referring to Trooper Michael Proctor as the co-lead investigator. So that's going to be interesting. Having a Wi-Fi issue, so hang on a second here. Hopefully that does not disrupt this feed. If I swipe out, I will swipe right back in. We should be good. Okay, good. I don't think there was any interruption, but I could see the Wi-Fi thing came up, and I was supposed to be on Ethernet, so I had to switch it. Okay, you don't need to hear all the details, but yes, so there is an internal affairs investigation. Michael Proctor, lead investigator. They've recently started referring to him as the co-lead investigator. So what we hear next makes me think that all of a sudden they're going to start saying, well, we don't need to call him to testify. We can call in the co-lead investigator because they do not want to open him up to cross on the internal affairs investigation. It's obvious. I don't think it's going to work, but again, every day is a new day here in the courtroom of Norfolk Superior Judge Beverly Cannoni.
So there were some interviews in regard to any sort of areas of potential bias with regard to Trooper Proctor and certain members of the Albert family. That was something that we did. So we had asked a couple of captains from the state police who are completely divorced from the investigation and completely divorced from our office, conducting interviews with regard to Trooper Proctor and a few of the other civilian witnesses.
Okay. How recently? I mean, it's all recent. When was that?
That was, I think, all discovery related to that was provided to counsel the week prior to trial.
Okay.
Oh, the week prior to trial. Trial hasn't really started yet. I mean, jury selection did, but so that was what, maybe, I don't know, tops 10 days ago or so? Maybe a little bit more? You just can't make it up.
But they were done sort of in the weeks leading up to that.
Is that part complete?
Yes.
Okay.
So as far as the IA investigation goes, just the mere fact that there is an IA investigation, the Commonwealth would submit is not an appropriate area for cross-examination,
Oh,
particularly
yeah, it is.
when it's an open investigation. There are no findings and falls squarely with.
Anybody else think they're keeping it open on purpose and there's been no findings yet on purpose because of this murder trial that's about to happen that he's the lead investigator in? And also maybe because he's also the lead investigator on the Brian Walsh case. Anybody know about that case? Brian Walsh, who is accused of killing his wife, Anna Walsh, in the same exact county, in the same exact courthouse. He's got a reason to testify in a certain way if he wants his internal affairs investigation to go a certain way so that he can keep his job. So yeah, I would submit to you that, yeah, it absolutely 100% is fodder for cross-examination. But, you know, I'm just living out here in the twilight zone as a civil litigator. So what the hell do I know?
Within McFarland and Graham. And I understand what the court's comments before about, you know, them being primarily discovery cases, and I would agree with that. But they also go to discovery cases as far as what, so if something can't be ordered to be provided in the course of discovery, then it's, I would submit inferentially inadmissible. So what I'm suggesting with this motion, what I'm arguing in this motion is that whereas there is no findings of liability, there's no findings of any wrongdoing or anything of that ilk, just sort of putting out there that there's an open IA investigation without anything more because nothing else exists at this point.
Why wouldn't it go to his bias and his motive? You know, if he's under investigation, why wouldn't he have the motive to testify favorably, or why doesn't it go to that? Maybe not the fact that it's IAD, but just there's an ongoing investigation that he's aware of, that he's involved. And you know, I don't know if his job depends on it. I don't know that. Maybe there's not enough to know. But why isn't that motive and bias on his part?
He's looking dumbfounded, and she keeps talking because she knows that she needs to give him time to come up with an answer. So she keeps talking. Is that me?
Do you think that's prohibited by Graham and McFarland?
I do. And just for that specific.
I mean, it's like she's leading him with questions. He's using leading questions on him. Like he's a 13-year-old witness. Do you think that the case is the, you know, wink, wink, nod, nod. Say no more. Say no more. Anybody name what that's from? Say no more. Wink, wink. Say no more. Shigoa, your wife, eh? Say no more. Yeah, she does, Carrie. Spoon feeding.
Because essentially what it allows a defendant to do is to pursue a line of questioning that they have no idea what that line of questioning is or what it will eventually be. And it could eventually turn into nothing. And to allow that sort of imprimatur of the court to allow that sort of questioning into an area that is completely unsettled and completely, there's no evidence to substantiate other than the fact that it exists. Without any sort of finding, without any sort of evidence to support it. I mean, we don't have any evidence as far as what that is, or that it even pertains to this case. So
Mm.
with regard to
You don't know that the internal affairs investigation pertains to this case? Really? Did he really just say that? Really?
all of that, I understand, that outside of McFarland and outside of Graham, that there are other avenues, as the court was alluding to, as far as motive, as far as bias, as far as things of that nature. But when it's just so scant as far as what that is versus sort of the connotation behind those questions, I just think it's unfair to the Commonwealth. It's unfair to the witness to.
It's unfair to the Commonwealth and it's unfair to the witness. And then you hear, how about the fair trial that the defendant Karen Reed is guaranteed under the Constitution of the United States of America, my friends? How about that right to the fair trial? All we care about is whether it's fair to the Commonwealth and the witness who is under internal affairs investigation lied to the state grand jury to get this indictment done.
To be put in that position when there's really no information available.
It doesn't, you don't need information available. The fact that he is under an internal affairs investigation is enough. It speaks volumes to the jury. Volumes. Can't make this up, peeps. You can't make this up.
Little.
Your Honor, I think that ADA Lally's representation that we don't know what this investigation is about is disingenuous, to say the least.
Why so? Why? Is there
Reason
something in
is-
the, hold on, is it something in the information that you've received
Yes, Your Honor.
from
And
Mr. Lally?
yes, Your Honor.
All right, so can I get a copy of that?
Yes, Ron.
Okay.
So, as the court knows, first of all, Graham and McFarland deal with the Commonwealth's mandatory discovery obligations, right? Those courts also very specifically state that there's mechanisms outside of those mandatory discovery obligations for defendants to obtain information that's relevant and admissible at trial. That's why we filed a Rule 17 motion requesting these disciplinary records, and that's why that was granted.
It was granted because the Commonwealth did not object.
So,
Regardless, so Judge, are you saying if they objected, you wouldn't have allowed it? It was granted because they didn't object. Are you kidding me right now? Are you kidding me? Wow.
obtain those records. And the cases that Mr. Lally continues to cite do not stand for the proposition that that's the only mechanism by which information can be produced at trial. Those are discovery cases. They are not admissibility cases.
Yes, Liza, yes.
Pursuant to that request, we have received information discussing the IA investigation at which Trooper Proctor is being questioned specifically about this case. This is not an instance where we're questioning whether or not there's a basis for an IA investigation. It's clear this investigation was predicated on the materials that were produced to the Commonwealth by the federal authorities in this case.
And initiated by the Commonwealth. The IID investigation was initiated by the DA's office.
Oh, bravo, bravo, DA's office. Congratulations for finally conducting an IA investigation. Like, really? She's giving him, she's giving the Commonwealth credit for the internal affairs investigation. Yes, her voice does quiver when she gets angry. You can tell. Some people think she's nervous. She's not nervous. She is mad. And she knows the case law. And you'll notice that she gets up to argue the cases because she knows that case law backwards and forwards. She's like, Judge, this case law that you're citing and that he's citing has to do with, you know, not this issue. And she's right.
That's correct.
Well, as far, and just to correct what I certainly didn't mean to impute that this case had absolutely no bearing or there was no.
I didn't think you did.
But what I was saying with that is we don't know what the full extent of that is. But as far as what counsel is, what the court's question as far as the IAD, it was something that our office had spoken to. We felt we had a duty to disclose to State Police Legal Counsel, and then they refer it to the IA, and that's how that investigation began. As it pertains to what counsel was talking about, that has nothing to do with IA. So the materials that the Commonwealth has provided, that was completely separate investigation initiated by the District Attorney's Office.
Okay.
That.
Okay.
The IA investigation came on the heels of this information being produced to the Commonwealth. This is not a situation in which we're really questioning what the basis of that investigation is. The Commonwealth has in its possession numerous materials that suggest there has been significant misconduct on the part of Trooper Proctor. That will come out at trial.
How?
However,
How?
through cross-examination.
What if they don't call Trooper Proctor
We will call Trooper Proctor.
to impeach?
Hold on, because not only did I start laughing out loud when I heard this yesterday, I had to rewind it like 3 times. And then I had to rewind it to listen to the people in the courtroom laughing. What if they don't call Trooper Proctor as a witness? He's the lead investigator in this murder investigation, Your Honor. Are you kidding me? We're going to rewind it for effect. And also while I fix my camera issue. I'll be right back. Don't worry, but you're going to get to hear this.
Legal counsel, and then they refer it to the IA, and that's how that investigation began. As it pertains to what counsel is talking about, that has nothing to do with IA. So the materials that the Commonwealth has provided, that was completely separate investigation initiated by the district attorney's office. in
Okay.
relation to that.
Okay.
The IA investigation came on the heels of this information being produced to the Commonwealth. This is not a situation in which we're really questioning what the basis of that investigation is. The Commonwealth has in its possession numerous materials that suggest there has been significant misconduct on the part of Trooper Proctor. That will come out at trial.
How?
However,
How?
through cross-examination.
What if they don't call Trooper Proctor
We will call Trooper Proctor.
to impeach him?
Yes.
All right, so be prepared to argue that. I don't know. He's on the witness list. He's the first person on the witness list. They're probably calling him. I'm just
He's the lead detective.
hypothetically.
I don't know. He's on the witness list. They're probably going to call him. He's the first one listed. I mean, I don't know. Wow. How about this? If they don't call him, we're calling him. How about this? If they don't call him, the case will be dismissed at the close of evidence because they haven't proven a prima facie case of murder without calling the lead investigator to testify who had his hands in everything. That was just. You little millennials out there need a little soundbite for your little video that you're going to make. Pull that one. What if they don't what if they don't call Trooper Proctor to testify? There's a good little soundbite for you.
This case. He's conducted every single step of this investigation.
With others, right?
Excuse me?
With others.
With others.
Sometimes, but he is the primary investigator in this.
With others, like he had a co-lead investigator. Maybe they could call hint, hint, wink, wink, nod, nod. Say no more. Say no more. You go?
Case. And I think it's very, very important for the court. And I think you noted correctly that bias and motive are absolutely critical to Ms. Reed's right to defend herself at trial. We have to be able to explore those issues. And in order for Trooper Proctor to testify, he has a motivation to testify in a certain way to avoid liability in this pending IA investigation. So I think it's unfair to tie our hands behind our back and not be able to question him about this, because it directly drives his bias and motive in this case and gives him reason to testify in a certain way, knowing that he could face career consequences if he doesn't.
Do you intend to try and open on this, Ms. Gianetti? Because I need more information.
I'm not going to mention the IA investigation in my opening statement.
All right. So, Mr. Lally, if you can get me that information that you mentioned that you had sent to counsel, I'll take a look at that. It may well be the fact that there's an investigation without what the nature of the investigation is, but that there's an important investigation. And if you can show me in advance that his job may depend on it, things of that nature, there may be cleaner ways to allow this testimony.
You need to show it? Really? How? How are you going to show that? It's obvious. It's obvious to anybody who's even watching this case for the first time today that the fact that the lead investigator, state trooper, is under internal affairs investigation for his handling of this murder investigation within his own department is 100% going to be relevant to his testimony. So she's not even really ruling on this right now, I feel like. And I think that she doesn't, right? So is she going to reserve this one too?
Yeah. So, all right. So we need a little time. I need to read those materials.
Yeah.
Sure. And,
Okay.
and for the court's edification, I don't anticipate he's sort of towards the middle, I would say.
Okay. All right. Good. And the more fully the records developed and the easier to rule on some of these motions. I just
Right.
want to give you all some idea so you know how to prepare for the next 2 weeks. So,
Defense is like, we don't need to prepare. We're ready. We are ready on this. We've been ready for 2 years on this. Doesn't matter that you just threw this internal affairs investigation. And by the way, she gave credit for Norfolk County District Attorney's Office for starting the internal affairs investigation. Like, wow, job well done. Pat on the back. My employer, the county, the district attorney, decided to start this internal affairs investigation. So yay us. They don't need time to get ready. It's not only disingenuous, it's insulting. What is in her Yeti? What is in her Yeti? I don't know. I don't know.
all right. So not in your openings on either one of these, Mr. Yannetti, but you agree to that. So this is still under advisement. It may be certainly with Lank or Sergeant Lank of voir dire of Sergeant Lank and of voir dire of Chris Albert.
Okay.
We'll see
Can't
how
wait.
the evidence develops, and I'll read more about the information that the Commonwealth was provided. So 318, also it's 28 bolded from the Commonwealth. All right, so Commonwealth's motion eliminate to admit, this is, you know what, I don't have a number on this one, Jim. Commonwealth's motion eliminate to admit results of defendant's blood draw at Good Samaritan Hospital and resulting serum conversion and retrograde extrapolation.
Judge, that's paper 339.
All right, and the Commonwealth, I mean, the defendants is 289. It's the addressing the same issues. Yeah, I told the Commonwealth to put this in writing. So I guess it's defendant's motion. So I'll hear from the defense. Your motion 289.
Thank you, Your Honor. With regard to that, we've put most of our argument in the paper, so I don't want to rehash all of those. The issue is really the foundational issue, not the extrapolation. The extrapolation is sort of a garbage in, garbage out argument, like computers. We think that the underlying blood draw did not follow the proper protocols that it should have followed. Therefore, the veracity of that particular blood draw is at issue.
All right, can I just ask, the Commonwealth intends to have witnesses here to testify to that, right? How the
Yes.
blood was
Like-
drawn.
Like under their own standards in Massachusetts, it's not up to their own standards. That's like statutory. But
Yes,
all of
the
that.
Commonwealth would have the doctor that ordered the blood draw, the nurse / nurse practitioner, I summons both as far as who took the blood, and then the director of the lab at the Good Samaritan Medical Center. What I
Okay.
hope to...
So let me get back to Mr. Jackson, and then I'll hear you on that. I just wanted that. I'm not sure we had all that information when you filed the motion, but does that change anything, Mr. Jackson?
It doesn't, because the individuals that did the blood draw, it wasn't done in an accredited manner. I'm not arguing with the fact that the blood draw was taken, that somebody with a phlebotomist actually took the blood, but it wasn't done with the protocols or the accreditation that's required under Massachusetts state law and the Massachusetts State Police Crime Lab. Their protocols were, I apologize, their protocols were breached internally. And given that breach, we believe that any extrapolation based or founded upon those faulty blood draws, those unaccredited blood draws, are suspect as well. So the sum and substance is that you can't trust the extrapolation if it wasn't an accredited and a foundationally solid blood draw to begin with.
So if all the witnesses are here for cross-examination, why doesn't that go to the weight of the evidence instead of the admissibility?
Because we think that the admissibility is based on the protocols that the Massachusetts State Police have put in place. If they didn't have accreditation protocols, it wouldn't mean anything. It probably would go to the weight, not the admissibility. I think the admissibility is predicated on their own rules. They don't get, in our view,
Alimata, where are you when I need you? Because, you know, I need a real criminal defense lawyer in here, a fiery pit bull like Alimata. Soon, my friend, soon. We're planning something. Yeah. What he's saying is all true.
they don't get to break their own rules and then say, oh, well, let's just let it go to the weight, not the admissibility. We believe that it's important enough that it shouldn't ever come in front of the jury in the first place, notwithstanding the fact that we could obviously cross-examine them on the lack of accreditation. We think that it rises to the next level of not being trustworthy, and therefore it's overly prejudicial.
Yeah, just a tad.
Okay. Mr. Lally, doesn't this happen in hospitals across Massachusetts on a regular basis?
It does, and just to be clear, nobody's breaking anybody's own rules. This wasn't blood work that was taken by anybody at the lab or tested at the lab. It was taken at the hospital, tested at the hospital, and
But it was taken because why, my friends? You know, because Karen Reed was sectioned. She was dragged into the hospital because Sergeant Good on his body cam footage says, I'm going to section her, which is an involuntary psychiatric hold in Massachusetts. I think you call it Section 12. New York, we call it a 5150 or a 72-hour hold. And that is why her blood was taken. She was not taken to the hospital as a DUI or an OUI, as you call it in Massachusetts. And they did not have a trooper come down or someone sanctioned by the Massachusetts State Police or the Canton PD to draw her blood as they would in a typical drunk driving case. Those are the facts. I'm sorry if you don't like them, but those are the facts. It was taken secondary to her being sectioned by a tech at the hospital, and Massachusetts has a specific law for this.
Technician or the forensic scientist from the Office of Alcohol Testing is doing is essentially mathematical calculations based on that result. So I would submit it goes exactly to the weight of the evidence. It's certainly fertile ground for cross-examination or argument by counsel. But as far as it being admissible, it's
fertile. They're going to be like the Octomom after this. You want to talk fertile? Here's a good soundbite for you.
It's certainly admissible. This is what happens in every case. Whether or not Good Samaritan Medical Center's lab is ANAB accredited or anything of that nature is irrelevant. It has nothing to do with the state police strictures because they're not the ones who actually conducted the testing of what was in the blood.
All right, do you want to respond?
I just wanted to refresh the court's recollection. I mentioned this at the last hearing, but just one element of the problem is in the result. The extrapolated result was 124% swing. In other words, we extrapolated based on the blood draw.
Yeah, I know what it means.
And that's just massive. I've never seen a swing that big. It's, you know, you pull somebody over. Well, they
sounds like a great area for cross-examination.
I think it will be.
Okay.
But if it's not admissible in the first place because it's inherently untrustworthy, then you could save me my breath.
Yeah, you could save me my breath, but he knows what's happening.
Yeah. I don't see how this doesn't come in.
Okay.
I'll submit, I don't want to beat a dead horse. I just think that it's so unreliable that it shouldn't be put before the jury. And we run the risk of prejudicing the jury in a way that we can't sort of unring that bell. Yes, we can cross-examine, but I don't think that the underlying blood draw is foundationally solid enough.
Mr. Lally, were you planning on using this in your opening?
I don't have to.
All right, so why don't we wait and if need be, we'll have the experts. Let's wait until it gets closer to these experts or the folks from the hospital testifying. If we need to have a short voir dire, you need to remind me to do that.
So it's coming in or it's not coming in? So it's coming. We don't know if it's going to come in because when we bring the witnesses in, because we're going to drag them in anyway, because I can't possibly make a ruling on this now, even though I'm screaming at everybody who's not getting me everything on paper. But I'm not going to make a ruling on this now. We're going to call these people in and then we're going to see how it's going. I mean, okay.
Mr. Jackson, okay.
Thank you for that, Your Honor. Appreciate it.
All right. Okay, so the last area I have is sort of logistics and sequestration. So let me, so the Commonwealth filed a motion initially. You know what, we'll hold off on the logistic.
Sequestration and the way they are using it in this motions is not as in sequestering a jury when they put you in a hotel during deliberations and keep you away from your family for weeks. Sequestration means that if you are a witness, you must not be in the courtroom for any of the testimony until after you testify, and that is the way that they are using it for these motions.
Regarding the audiovisual assistant. So there was a motion in limine for sequestration that I allowed regarding the family. So the victim's brother, Paul O'Keefe, the sister-in-law, Erin O'Keefe, the niece and nephew can attend the trial after their testimony. So that motion 293 is allowed. I understand that perhaps, well, I was going to also allow Mr. O'Keefe's father, who appears for some reason on the defendant's witness list. He is exempt also.
For some reason, now she's questioning the defense's ability to call Officer O'Keefe's father to the stand. I mean, is she throwing shade on that or what? Is it me?
By me from the sequestration order. All right, so that's John O'Keefe Sr. So I just added that in. So Mr. Clerk, 293 is allowed with the addition of Mr. O'Keefe
Thank you.
Sr. So the Commonwealth has filed a two-part motion, a motion for offer of proof regarding calling the elected sitting district attorney of Norfolk County and sequestration order if he is permitted to be called. This also includes Stephen Nelson, who is the victim witness person. So why don't I hear you, Mr. Lally or Ms. McLaughlin? I'll hear you on this motion.
The victim witness person. This is going to get spicy, juicy. So let's go to the chat just for 1 minute so that we can thank some people. Jennifer, you became a member. Congratulations. And thank you so very much. Sarah, thank you so much for your generous super chat. Excellent stream and legal analysis, and appreciate you breaking down the legal lingo. Mom has just moved into palliative care, so having trouble focusing. Oh, I'm so sorry, Sarah. I'm so sorry. Prayers up for Sarah's mom, everyone. Sarah's mom watches the show as well. And she says, plus Bev is really pissing me off. We'll come back later. And Sarah in her profile picture is wearing merch that says, I think it's the tie-dye that says, come for me in the comments. Sarah, we are all praying for your mom. That breaks my heart. I've been through it, so I know what you're going through. An Eclective Mind became a new member. Thank you so much. And Susan Constantino, thank you so much. Robin G, thank you so much. Lake Life 39, thanks for your super chat. My first super chat ever. Thank you. I am honored that you chose to spend your super chat with me. Is this normal pre-trial protocol? Seems odd to me that the Commonwealth of Massachusetts and defense need to get the okay from the judge of what they can present and what experts can say before the trial. Yes, this is normal pre-trial procedure. It is. So there are certain things, we have been calling them motions in lemonade because of some closed captioning that we laughed at one day, but they are called motions in limine here in the US. And these are motions that are made, well, I guess you're from the US because you super chatted in dollars. So these are motions that are made prior to trial to streamline the trial and also to decide which evidence will be included and which evidence will be excluded in case either side has issues with it. And so there are no like real surprises during trial, but this is very, very common. Yes, it is very common. Latina, thanks for your super chat. Hi, Melanie, New Yorker here. What's up? New York strong. Cold Spring Harbor. Right on, sister. Let's meet someday for coffee. CW doesn't want them to use the third party. What will the jury wonder when they hear Karen Reed accuse Colin and Brian Albert that they beat him up? Well, it's not that they're not allowed to use it. They're not allowed to say it in their opening. So whatever evidence they elicit during trial, that is, in her words, credible or competent evidence, and I'm sure there's going to be a boatload of it, it will come in. So don't worry about that. But they will be able to close on it. Whatever comes in during trial in a competent manner will be able to be closed on. So don't freak out. Jinxie, thanks for your super chat. Doesn't anybody believe that witnesses aren't watching all these pretrial videos? No need for poker faces, as hands are clearly shown. Thanks, Mel, for your grace and brilliance. Thank you so much, Jinxie, for thanking me. Sometimes I think that we're the only people out here in YouTube land. There's a lot of people that don't watch YouTube and don't know about YouTube. So they may not be. I mean, it's very possible that they may not be. I think once you get into this YouTube world, it's kind of like you forget about regular television and streamers even. I mean, how many of you watch regular TV anymore? When you can always find a friend to hang out with on YouTube, it seems like, live and a chat with people that you know in it. But I don't know. That's an interesting point. Warrior, thanks for your super chat. Powerful, independent women unite. Yes. These women who bash other women are so immature and self-loathing. Grow up. Love you, Melanie. I love you right back, Warrior B. Biatch. Oh, I see what you did there. Look, it's Warrior Biatch. Oh, I love that. Hi, Della. Thanks for your super chat. I am not a criminal defense attorney, and I see all you see. Thank you. Thank you so very much. Solomon Grundy, thanks for your super chat, who says the judge is so blatantly biased. We can see it. Maybe some other people can see it. I don't know. Maybe it's just our opinion. Christine, thank you so much for your super chat. Judge Beverly Lou Who and her snippiness. Hilarious and maddening. Wow, I never even thought of that, but she is reminiscent of Cindy Lou Who. It was Cindy Lou Who, right? In the old cartoon of the Grinch, the Christmas cartoon. She does kind of look like Cindy Lou Who. That's a compliment. Della, thanks for your super chat. Can a judge be wiretapped, investigated by the FBI? Yeah, I'm pretty sure the FBI can do whatever they want. But if I'm wrong about that, somebody correct me in the chat. But yeah, I'm pretty sure at one point she was disregarding the federal court order as if she had some authority to do that. And the U.S. Attorney's Office sent her a scathing letter like, you might not want to violate the federal order, because if you do, we're going to have to bring an action. And we don't want to bring an action. It's not the course of action we want to take, Your Honor. Shelby says, what? Thanks for your super chat. Not all of us millennials are idiots. No, I didn't say that. Suzanne, thanks for your super chat. The defense just received the video from the Sally Port yesterday. Yep. She's AKA Auntie Beverage. Sigh. Yep. They just turned over that Sally Port video with all of the missing footage yesterday. That is where the Karen Reed's vehicle was towed to on the evening of January 29th of 2022 from Dighton. And I'd like to see the warrant for that. Was there a warrant? Anybody know if they had a warrant to seize that vehicle? I'd love to know. I don't think that we've come across that in any of the filings that we've looked at. Karen Davis, thank you so much for your super sticker. Appreciate you so. Julio Suave, thanks for coming in. Thanks for your super chat. Law & Order Season 7, Episode 16. Can we review this episode when our heroes went to California? McCoy. A judge in LA has just ruled to nullify an extradition order. Speak up, Your Honor. There are some people in the Bronx who didn't hear you. All right. You know what? I am a huge fan of that show. As you guys know, I'm writing this down right now because my kids and I watch it all the time. The rerun, the repeats on wherever it is right now. I forget where it's living. It might be Netflix. I'm not sure. All right. Or it might be Hulu. Season 7. Episode 16, and with McCoy, that is the original Law & Order. Okay, it's homework for everybody. Let's do that. Thank you, Julio Suave, for your very generous super chat. Chief Sherry, thank you for your super chat, for your laughs, your facial expressions are the best. A laugh as good as the guard. People, it's one thing they love to make videos about my facial expressions and make fun of them, but I'm having fun. So as long as you guys are having fun, screw them. Holly Mack, thanks for becoming a member. Maureen became a member. Thank you so much. Madam Ross, can the judge interrupt during openings? No, she's not supposed to. In fact, it is in very poor form to object during your adversary's opening. But some lawyers do it to throw off the flow, and I don't think it's proper. I mean, unless they go way out of left field and they start saying stuff in their opening that they've already been told not to say, like third-party culprits, etc. But it is in very poor form to object during an opening. To have a judge interrupt you during opening, that's like, that should never happen. But, you know, again, nothing would surprise me here. Charlene, here's more money for my swear jar with this case. That's okay. That's okay, Charlene. We're not going to hold it against you. All right, let's go back. Let's go back and see what she's got to say next.
Yes, Your Honor. So the reason for this motion is, as the court noted, they appear on the defendant's witness list. Neither of them, I believe, has received a summons in regard to it. So there's no motion to quash because there's no summons to quash. But with respect to each, as the case law is abundantly clear, in order for these witnesses from a prosecution team to be subject to being called as witnesses by the defense, the Commonwealth is just seeking some sort of proffer whatsoever as to what areas they can testify and only they can testify to. So if it's information that the defendant can elicit either through direct testimony or cross-examination from, and I would submit whatever, I would believe that whatever testimony they seek from either of these witnesses, they could get ample testimony from a multitude of other witnesses. Specifically, the only point that was raised as sidebar during impanelment was with reference to the district attorney testifying as to whatever issues, reported issues of conflict or removal of Canton Police Department from the investigation. Certainly those are questions I think far more appropriate for members of both the Canton Police Department, members of the State Police CPAC Detective Unit. The head of that unit, Lieutenant Tully, is one of the Commonwealth's witnesses who will be testifying, and I think he's in a far better position to testify to that than Mr. Morrissey. But regardless of that, what the case law is very clear about is that, number one, the victim witness advocate is a part of the prosecution team, and in these sort of areas stands in sort of the same stead as a prosecutor himself. Secondly, with respect to whatever areas of examination are expected or anticipated from these two witnesses, there has to be some sort of proffer of what that anticipated testimony would be that they can't get from some other witness. Certainly, Mr. Nelson has been the victim witness advocate working on this case.
So why don't you explain to me, I did look at the victim's Bill of Rights, but why don't you explain to me exactly what a victim witness advocate does, the nature of the relationship with the victim's family? I know there was a lot of discussion about this in grand jury minutes that I read about scheduling appointments, meeting with people, things of that nature.
Why don't you explain it for the TV viewing audience, Mr. Lally? Because we all know that I know what it is, and we all know that you know what it is, but let's get it out there.
So, I mean, what to say assist, I think is doing it somewhat of a disservice as far as the prosecution. It's someone who works directly with the prosecutor on virtually every step of the case, as far as investigation, as far as pending motions, as far as trial.
Has Mr. Nelson been the advocate throughout the pendency of this case?
Yes, Your Honor. So for over 2 years, has been the point of contact with the family, has been with the family at each of the court dates, is assistant and very helpful as far as coordinating things with the family, coordinating meetings, scheduling meetings with witnesses in preparation of grand jury, in preparation.
But not just the family. Not just the family, the percipient witnesses in this case, the material witnesses. Because the family doesn't really have a lot of testimony. The people with the most of the testimony in this case are the witnesses who were in the house on the night, early morning hours of January 29th of 2022. And there are a lot of them, and they are, most of them are related and or law enforcement. So I think that's what they're a little bit more afraid of, as you will see, because it's going to come out. No spoilers.
Of trial, has communicated thoroughly with regard to issues of scheduling and all of those types of things.
Does he take calls like late at night from witnesses? Does he have a personal relationship with witnesses?
What an
governed by.
odd question. Does he take calls late at night from witnesses? That's an odd question. I'm just picking up on this right now. If anybody's picking up on what she's laying down, tell me what to make of that. Because I don't think they got phone records from the victims. Did they get phone records from the victim's advocate? Tell me, my friends. Yeah, Nosy Rosie, that was a super weird question. Butt dials late at night. Yep. Is that not a setup question? Yeah, this is the first time I'm picking this up. I was a little distracted when I was watching this yesterday.
Professional relationship. Is he somebody that they are able to call?
Biden?
There's been a lot of allegations of harassment of witnesses. Those folks.
Oh, there you go. There you go. Get it out there again.
Folks able to call him when something like that happens?
That is the person that they would call. Yes. So
Mhm.
I think the bulk of the communications and conversations with witnesses who are not members of.
Then maybe, just maybe, if they were being harassed by, not Karen Reed, by the way, if they were being harassed by another third party, perhaps they should have gone to Mr. Nelson's house late at night. And perhaps their cars should have been found at Mr. Nelson's house instead of Trooper Proctor's house. Okay. But now I do like that question because there you go. If they had a relationship where they could take calls late at night, because he just said that. Is that who they would call if they were being harassed? Yeah. So why didn't they go to his house? Why wasn't he at their house instead of them being at Trooper Proctor's house? Okay.
Of Mr. O'Keefe's family over the course of the last couple of years have been in relation to that issue specifically, as far as harassment, threats, intimidation, things of that nature, that he's dealt with admirably in relation to those witnesses.
Okay. All right. Who's arguing this for the defense?
I will, Your Honor, and I think it makes sense to separate out DA Morrissey and victim witness advocate Steve Nelson in
Okay.
this argument.
Let's start with Mr. Nelson.
Sure. Your Honor, the defense acknowledges that there are often times where, let's say, a victim witness advocate sits in on an interview with a witness or an alleged victim, but there are other witnesses in the room to whom or who could testify about the content of that, and that doesn't necessarily make it proper to call a victim witness advocate during a trial. I acknowledge that. I also acknowledge that the victim witness advocate has a job to do, and it puts them as sort of an intermediary between the prosecutors and the police and alleged victims.
So when you were a prosecutor, you worked very closely with victim witness advocates.
I did.
Okay.
Yes, and it's my experience being on the other side that informs my knowledge of that. But this is a different case with regard to one specific issue, and that is that we learned as a result of the federal materials that victim witness advocate Steve Nelson had conversations with Brian Higgins and we believe Brian Albert.
Okay. Hold on. The victim witness advocate, OB says, did a dog just bark in court? I know, I heard that too. Somebody have like whooping cough? Watch, I think these are reporters right here, right? Can you see my cursor on the screen? Maybe not. So right to the behind Lally, sitting in the first pew here with laptops, are two reporters. Watch their faces when he says this next thing. I'm going to take it back just a smidgen.
Of the federal materials that victim witness advocate Steve Nelson had conversations with Brian Higgins and we believe Brian Albert, but Brian Higgins talked about him specifically. Mr. Higgins was asked, where is his cell phone? Why does he not have it? Are you aware of the preservation order that was issued by Judge Krupp in the Karen Reed case? And the answer came back that he was given permission to destroy or dispose of his cell phone from victim witness advocate Steve Nelson.
Did he say destroy? I'm trying to remember the
Well,
testimony. I don't think he said destroy.
I used the disjunctive rather than the conjunctive because from memory, I can't remember the precise language, but it was conveyed to.
Even the cameraman started shaking.
I'm told.
Even the cameraman just started shaking. He's like, what? Everyone thought it was Michael Morrissey's office who told him he could destroy his cell phone or do away with his cell phone or dispose of his cell phone, but it was the victim witness advocate. What? Has anyone done a deep dive into the background and CV or resume of the victim witness advocate in this case? If you have, put it in the chat what you know, how long they've been a victim witness advocate, what we know about them, if they have any other background in law enforcement or anything else. But what? There was an order in place. We looked at it the other night or however many nights ago. I think we're up to maybe 60 or 70 hours of coverage on this case. So if you don't want to read all the court documents yourself, go back to the beginning of my however many videos I have on this case and start from the beginning, and we'll go through all of them. There's a preservation order that was signed during the arraignment, which we watched recently, maybe in the past 3 shows in February, which was the day that Karen was arraigned the first time, that the judge signed, indicating that nobody was allowed to dispose of any material evidence in this case, including cell phones. So if the victim witness advocate gave the go-ahead on this, it's a problem.
That the precise language was to get rid of, which, would be consistent with what I had
Told
said.
he could get rid of, not
Right.
told he must get rid of.
Correct. In other words, Steve Nelson is overruling a colleague of yours, your predecessor on this case, who issued a preservation order which was never lifted. And yet he stepped.
Oh, yeah. Is he a lawyer? That's what I want to know. Is this victim's witness advocate a lawyer?
Into the case, gave authorization that he did not have to give for the disposal of a phone, which is relevant.
Okay, is that the sole issue you want to?
Yes.
The sole issue.
Yes. That's
Okay, can you stop talking now? I'm going to cut you off and not let you say anything more. But is that the only reason that you want to call this victim witness advocate?
with regard to Mr. Nelson. It's different with regard to Mr.
All right,
Morrison.
what's the Commonwealth's response to that?
I don't believe any of that is accurate. So
Good.
what
Cross-examine
counsel
him.
is referring to is there was a motion to preserve
Yes,
cell
I said.
phones. The Commonwealth
Cry about it. Cry about it. Too bad, so sad. It's in the federal testimony. So it's coming in.
notified each of the witnesses that were subject to the motions and the orders, sent copies of the motions and the orders, as well as a letter explaining that. There were conversations in regard to that. There was then a subsequent Rule 17 motion filed specifically for the physical phones. There were conversations with those specific witnesses, just advising them that the Rule 17 motion had been filed. They had to, hold on to their phones, things of that nature, explaining what the process was. The hearing was conducted, the Rule 17 motion was denied, and then those witnesses were subsequently informed that the motion had been denied.
Okay.
I believe.
Whoa. The Rule 17 motions, which for those of you who are not familiar with Massachusetts law, Rule 17 motions are made for third-party discovery. Parties who have, no skin in the game of this case, except for maybe their witnesses, and they're allowed to come to the hearing with their attorneys, which they did do. And there were Rule 17 motions to get a hold of their cell phone records, including Higgins and Brian Albert and Jen McCabe and some other people involved here. But those were not, they've been some of these Rule 17 hearings have been very recent. I don't remember exactly. I'm sure that somebody has a spreadsheet on this somewhere. But when exactly Higgins' Rule 17 motion was heard, because if we're going to talk about Higgins, let's talk about that. And then let's talk about the fact that he brought in to his testimony to the state grand jury, or handed over, had one of his federal buddies access his cell phone records or database, or, tap right into Verizon's, HQ or whatever, and pull only text messages between Higgins and Karen and Higgins and John O'Keefe, and brought them printed out, something like 50 pages of messages to his testimony. So when do we know the date when he destroyed his phone? Do we know the date of the Rule 17 motion? Do we know the date that he testified in front of the state grand jury? Because that was, I think, sometime, I don't remember if he brought those into the grand jury or if he handed them over to one of the investigators. But this is not as, silly as Mr. Lally is making it seem. And we also know that on February 2nd, I believe it was, when Karen was first arraigned for the first manslaughter charges before they upgraded to murder, her counsel, Mr. Yannetti, was handed a police report. And in that police report were a list of witnesses and their cell phone numbers and some photographs. Then, during discovery, they were allegedly given the same police report, but there were some changes to that police report. And the changes were specifically, correct me if I'm wrong, I know you will, Brian Albert's cell phone number, which now had a different number and a different cell phone carrier. And then there were also some photographs attached to that police report. So while they thought they were handing over the same police report again, it was really an amended police report with some additional new information crossed off, whited out. Remember whiteout? Do they still make that stuff anymore? Probably not. So he's minimizing this to the nth degree. But we who've been through all of the court documents, records, subpoenas, hearings, no.
Even from Mr. Higgins' testimony in the federal grand jury, the counsel is referring to, he was specifically asked whether or not he had been ever advised by Mr. Nelson, myself, or anyone from our office that he could or should get rid of his phone, and he said no. So I don't know what further needs to be explored on that particular point, as
Really?
the question was, all of these issues were explored in that particular area. And just because counsel, I think, may not like the answer or doesn't believe that the answer is truthful or whatever, that does not then permit bringing in this witness to testify to what they know is not true.
Because it wouldn't be fair
All
to
right,
us.
so Mr. Yannetti?
We believe that that's a misstatement of what was testified to. I think it probably makes sense for this court to look at his very testimony so that you can make a decision on this, Your Honor.
So here's what I'm going to do. Let's wait and see. Let's wait and see how Mr. Higgins testifies. Okay. I am not going to order sequestration of Mr. Nelson, and let's see how the testimony is. And if you need to call him, you let me know, and we'll have another hearing on it.
Okay, we'll do. And just to answer an anticipated question from the court, I do not open on this issue.
You cannot open on that issue, Mr. Yannetti. Do you still need the 45 minutes?
That takes away nothing from my open.
I love that. Do you still need the 45 minutes? That takes away nothing from my opening, Your Honor. Love that man.
All right. So, Jim, I'll start writing. I'll write something on this.
Your Honor, with regard to the sequestration, I think it would be appropriate for the court to order that Mr. Nelson and Mr. Higgins not discuss this issue from here forward.
Are you willing to have that happen, Mr. Lally?
That's fine, Your Honor.
Yeah, I'd order it, but he's willing to do it.
Thank you.
All right. So,
An order might be better.
I just need a minute to write this up.
Sure.
It's Karen's family, her parents, her brother. Fast forward this a little bit. That is John O'Keefe's brother, Paul. That is Mrs. O'Keefe. My heart breaks for them. And my prayers and all of our prayers go out to the O'Keefe family as well as the Reed family.
The district attorney in Norfolk County can, of the defense, certainly alive.
All right. So regarding DA Morrissey.
Yes, thank you, Your Honor. So, Your Honor, the integrity of the investigation that was done in this case is certainly a live and important issue that is part of the defense in this case. I think the court would agree that we're entitled to question the integrity of the investigation, to attack it where we can. And it goes without saying that as the district attorney in Norfolk County, Michael Morrissey is in charge of that investigation. Now, in the usual case, that doesn't necessarily make a district attorney a witness. That would be unusual. There probably have been very few requests to have a district attorney testify in that regard. However, this
Because, in fact, Michael Morrissey even said in his hostage video, this is unprecedented. I've never done this before. And in fact, nobody has. And in fact, Mr. Yannetti said in court one day that a law professor that he knows actually took that hostage video and showed it to his law students and said, this is how a DA should never behave. And that's why you don't hear about this a lot, because it rarely happens, because it's unprecedented that a district attorney would make such a statement.
This case is different for two reasons. One is the conflict of interest regarding the Canton Police Department, which Mr. Morrissey was involved in. The second is the manner in which he injected himself into this case personally and made representations that we should be allowed to challenge.
Do you want to play that video?
Yes.
We haven't made that decision yet. It may be that we elect to play portions of the video. It may be that we just elect to question DA Morrissey.
I have to think of other ways, right? That's part of the analysis that I have to follow in the law. So that's why I'm asking.
Of course. And I think before we get to that issue, Your Honor, the conflict issue is what puts him on the stand first. And we learned from the federal materials that former Chief Kenneth Berkowitz notified DA Morrissey at a very, very early juncture at 8:30 a.m. A phone call from Chief Berkowitz to DA Morrissey notified him that Kevin Albert is on their force. He's the brother of the homeowner whose lawn contained the lifeless body of John O'Keefe, and that.
Oh, DA Morrissey got a call early from Berkey, 8:30 a.m.
DA Morrissey was involved in that decision. He received the information from former Chief Berkowitz and concurred that the Canton police were conflicted out. And then the problem is that the Canton police they had their hands in this investigation, including that day after 8:30 a.m. and going forward. And there were, updates that were provided to Kevin Albert by a trooper under DA Morrissey's control, that, there were violations of that sort of conflict of interest taking Canton out of the case that DA Morrissey became aware of and that DA Morrissey did nothing about. And so in terms of, us being able to, attack, question the integrity of the investigation.
Why can't you do it through other witnesses?
We can, but the buck stops with District Attorney Michael Morrissey. He was the one that was involved at a very early juncture on this precise issue of the conflict, and he became aware that that conflict was violated time and time and time again, and he did nothing.
That's right.
And I believe that that's ripe for cross-examination. And, with regard to his statement to the press, this may even be more compelling, not because of the bias necessarily that he showed. That's not the strongest part. I think it is strong, but it's not the strongest part of his statement. His statement makes factual assertions, some of which we heard for the first time. In that videotape statement, he announced to everyone, including potential jurors, that Trooper Proctor never reported to the scene on January 29th. That's in direct conflict to police reports that we received from the troopers saying that they reported to the scene. And we would argue, trying to use semantics to get out of that, and now saying that for the first time in my career, I've heard that the crime scene is actually the police station that's across town. doesn't make any sense. It doesn't pass the straight face.
It doesn't pass the straight face test. Well, don't say who, but somebody else was saying that too. Well, the scene is anywhere. The scene could be anywhere. The scene's the police station. When they said Proctor came to the scene, it was that he came to the police station. Yeah, that could be the scene too. You know?
Test, but those are his own words, and he made himself a witness by uttering those words. And he also talked about his view of what witnesses did or didn't do and whether they're suspects or not suspects. Again, he injected himself into this case. He made himself a witness, and there's really nobody else we can question about his knowledge that he had when he made those statements and why he made those statements. And also the fact that, you know, he was involved in this conflict decision from the beginning. So that's our offer of proof.
Mr. Lally?
I mean, as far as his statements, his opinions are completely irrelevant. And I think what counts.
Are they though? Are they though? Are his opinions completely irrelevant when he gets on a video and disseminates it to the media and the worldwide YouTube audience and says that Trooper Proctor never arrived at the scene that day to 34 Fairview and he had no reason to plant any evidence and none of those people in the house were third-party culprits and they are being harassed and it must stop. It must stop. Really? Really? His opinions are irrelevant because he made them relevant by convicting Karen Reed, a defendant in his county that he is prosecuting, who has the presumption of innocence, my friends, under the United States Constitution, except in Norfolk County. So how can he get up there with a straight red face and say his opinions are irrelevant? His opinions tainted the jury pool last August of 2023 when he got on there with his 5-minute bloviated statement that was completely improper and it was unprecedented, and it is what law school professors are using in class to show their students what not to do as a DA. So you better dial that back a bit, sir. Counselor
is referring to as proper for cross-examination. They might be, but this would be a witness that they're calling themselves. So for direct examination of your own witness, I think it's improper, number one. Number two, there is ample other avenues to explore this through other witnesses, which counsel can certainly do. You know, as
the witness who wrote the statement, the witness who was holding a firearm at his head right out of frame. What other witnesses are going to come in and testify about his statement, counselor?
Related to whatever.
As the law tells me I have to consider.
Correct. And so, you know, as it pertains to whatever extent the court allows, as far as the Bowden defense is concerned, then I think it's fertile ground for cross-examination of other witnesses in respect to that. But as to whatever statements were made or not made, by something that someone doesn't have recipient knowledge of, because I don't think anybody's saying that Mr. Morrissey was at 34 Fairview Road. So with all of those.
No, but Mr. Morrissey is saying that Trooper Proctor was not at 34 Fairview Road. So which is it? He inserted himself into this case by stating these facts as actual, real, true facts. And as a district attorney, you are held to a higher standard than a regular attorney, than a defense attorney. You are held to the highest standard of avoiding the appearance of impropriety. We went over those rules too. This is laughable.
Things in consideration that I don't think that it's even close to a valid proffer as to why the district attorney or Mr. Nelson need to testify on their own as to any of those things. The last thing I would just note is with respect to Mr. Nelson, the alleged mischaracterization that I made in regard to Mr. Higgins' testimony is actually contained on page 140 of his testimony.
140?
140.
Could you read it? Do you have it there? If you don't have it there.
It's more so I don't know that I'm
okay.
to.
Okay.
Your Honor, if I could just add one thing that I should have mentioned, which is on this issue of whether there's another witness that could testify.
Yes, because you did say, yes, we can get it in through other witnesses.
Yes, except the one thing we can't get in through other witnesses potentially is the phone call from Chief Berkowitz to DA Morrissey, where, as I'm understanding it, there were only two people on that call, and the Commonwealth is seeking to take Chief Berkowitz off the witness stand as well.
Are you? I didn't see anything like that.
No, I'm not seeking to keep him off the witness stand. What I informed counsel is as to his current medical condition, and informed counsel that's why I didn't summons him. But I'm not.
Look, even Jim's face was kind of like chuckling a little bit. Jim's the clerk. Even Jim was kind of like, really? She's like, you took Berkowitz off the witness list? What? If you take Berkowitz off the witness list, then I have to let Marty testify. He better get well soon. I'm going to send him a fruit basket.
Condition and informed counsel that's why I didn't summons him. But I'm not seeking
I knew nothing about this.
prohibit
Okay,
him
yeah.
from testifying.
My understanding was that the prosecution didn't believe that he would be able to testify.
This is the first time I'm hearing any of that.
I didn't tell
All right.
her. Forgot
So
to tell ya.
it is a stretch. It is an uphill battle for you, Mr. Yannetti. I will allow you to revisit the ADA Morrissey at the close of the Commonwealth's case. Right now, that your offer of proof is not enough. I'll give you the opportunity to do it again based
thanks,
on
Judge.
the testimony that comes in. And I am not excusing him, or he is not subject to the sequestration order.
Understood, Your Honor. Thank you.
All right. So, Jim, I'll write something short on that. I've written the part about Mr. Nelson that I'll give you afterwards.
Great, thank you.
All right. So when we had our motion in limine hearing, I think we went much of the day that Friday. I don't remember if it was last Friday.
Yeah, it is an uphill battle for Karen. Someone said he had cancer. I'm very sorry about that, DeAndre. We do not mean to joke about anyone's illnesses here, and that is very sad. And we wish him prayers and good health and healing vibes. But the judge seemed very taken aback by that. She apparently has no idea about his medical condition, and she had no idea that he wasn't coming to testify. And it seemed to me that it took her aback, because if Berkowitz isn't going to testify, then Marcy kind of has to, even though she's pointing out to the worldwide TV audience that it is going to be an uphill battle in her eyes. But yeah, it is an uphill battle for Karen H-Bag. You are 100% right. Just like it's been this whole entire more than 2-year struggle. The struggle is real, but I have a feeling that you and I are going to be blown away by this trial.
Friday or the Friday before. I ended that with saying twice, is there anything else we need to discuss regarding housekeeping or logistics? And I was told no by both parties. And then I get a motion the following April 19th, the end of last week, about wanting to use not just having an a technology audio visual assistant at counsel table, but to use it's much more extensive than what I expected. The Commonwealth filed their motion and it was allowed previously because it happens in every single
point
case.
out that in every single major trial like this is a major trial. You know, you've been here for it. You've been here for however many hours we've gone over this case. It's a major trial. It is not uncommon for a major private defense team to have an AV expert sitting at their table with them to pull up documents, to pull up exhibits, because the attorneys are very busy thinking about what they're going to say next, and they can't be worried about pulling up the right exhibits, getting things up on the screen, and all of that stuff. Remember in the Maya Kowalski case, there was one of the gentlemen at the plaintiff's table, because Maya Kowalski was the plaintiff, who was the AV guy. He was the guy that we were like, that's the guy. He's the man. He was pulling up all the exhibits, everything. Like, that is not a whack request. She's making this like she's never heard of this before in her life. And how could they possibly spring her on this when the trial is supposed to start on Monday? And how could they possibly have room at their table for a guy with a laptop? It's almost like it's unheard of. We just got Wi-Fi last week. I mean, listen to this. This is insane if you haven't heard it.
These courtrooms, and the Commonwealth shares their equipment Please tell me exactly what it is you want to do. And I'm mindful also of the fact that during impanelment, while we were actively on trial in this case, and a critical part of the case, your audiovisual person, who I had never seen, was sitting where you are, Mr. Yannetti, talking to your client. So it sounds like he's taking liberties in this courtroom. And I need to know exactly what you need him for and what it is you intend to do. Keeping in mind also that we're going to be now in a much smaller courtroom. So.
Oh, yes, we didn't talk about that. They have moved the trial to a much smaller courtroom because apparently in the courtroom they're currently in, 6 of the jurors at least would be looking at the back of witnesses' heads. And while Mr. Lally said, well, no big whoop, they can still listen to their voices and hear their demeanor, they have agreed to move the trial to courtroom 25, which is way smaller. It is only going to have enough room in the gallery for both families and 10 press passes per day, which are going to be given out on a first come, first serve. Thank you for the Rangers score. Nice, nice, nice. Rangers up 2-1 against the Caps. 7:30 remaining in first period. Thank you, classy but sassy. Feel free to keep posting every time there's a change in score. I love that. You're here for me. And they're moving to that smaller courtroom, so the press is going to have to get in line pretty early. And they have to stand the whole time. And apparently, from what I hear also, somebody said there's no air conditioning in that courtroom. So it's going to be interesting. But it's going to keep the spectacle down a bit, which I think is good. But I don't want her to say all of a sudden, oh, there's no room for cameras in there. But I don't think she's going to say that. But, you know, can't have your AV guy in there. You should use remember when we were in elementary school, some of us, and when every time they would show like a video in class, they would wheel in that giant stand with that big TV on it that was like 20, 30 inches deep. And they would like wheel it into the room, and they had to have 3 guys who were on the AV squad in junior high wheeling that thing in. And I don't even know how we watched it. Was it reel to reel or VHS? I don't remember, but that's like what she's talking about here. Like, the defense is entitled to their technology expert, their screens, the way they want to show their exhibits. Like, this is insane.
Tell me, are there any agreements of counsel? Is there any, I know nothing about this, and I asked for information previously, so I could have thought about it and, you know, seen a demonstration or heard something. What is it you're asking me to allow?
Thank you, Your Honor. It's very modest. We did mention that we were going to ask for this.
But you didn't do it in writing, and you didn't give me specifics.
Your Honor, we asked you, and you then said, put it in writing. Then we put it in writing.
Oh,
but the first time it was brought up was.
Wait, oh, so they did put it in writing. So she's wrong. She's not going to admit that she's wrong, will she?
After I had asked about logistics. Go ahead. Tell me exactly what it is you want to do.
Okay, so it's a very modest request. Under ordinary circumstances, and we've utilized his services before, he would sit at counsel table and he would run sort of the AV to make it seamless and smooth for everybody, for the jurors, for the court reporter, for opposing counsel. He can put monitors at the request of the court, put monitors on the bench, a monitor in front of the court reporter, a monitor in front of the Commonwealth, and a monitor here, all small, relatively inobtrusive monitors. He also can run the system of AV, in other words, putting up evidence. I'm looking at evidence binders that Mr. Lally and I are going to be visiting about through the day today and tomorrow. There's hundreds and hundreds and hundreds of photographs in here, multimedia, that's going to need to be played and shown throughout the course of the trial. Instead of walking back and forth and doing it sort of.
No, and that's what we do every day in this courtroom.
Right, and that's what he does every day in courtrooms as well. I mean,
that's right.
All we're asking for is an accommodation exactly like the Commonwealth has. It's just easier for us if I'm up on a crossing.
Like, you're going to make us use the Commonwealth's equipment from 1978? Really? Is that what you're doing? Because of the wires? Well, she's going to bring up wires next. This is Twilight Zone type stuff. Okay, AJ, smooth as butter, Alan Jackson is from LA. He's not having it. He's like, what do you mean I can't bring my tech guy in? I prosecuted Phil Spector. I've represented Kevin Spacey, Harvey Weinstein. Like, you're telling me I can't bring in, as such, my AV guy with my, what?
Examination, or Mr. Yannetti is up on a cross-examination, and we say, okay, let's say we've got internal bait stamps that show photograph number 231, he'll know what photograph number 231 is he'll have an outline that tracks our cross-examination or direct examination.
So it will be only things that are in evidence or will be coming into evidence. You're not going to do that with disputed.
Absolutely not. We would never do that. If there's anything that's disputed or even remotely controversial, my habit and practice is to ask to approach the bench. We all walk up. I say, this is what I'm proposing to show the jury, and the court rules on it. No, all it is just a sort of a facile accommodation of seamlessly showing multimedia or playing an audio or playing a video for the jurors.
All right. What's the Commonwealth's position on this?
Your Honor, given that representation, I mean, that's precisely what we do in every case in which we have either Ms. Gilman or Ms. Crawford or whoever assisting with the trial. If that's what it's limited to, I don't know, about the additional monitors or things of that nature, whether or not, especially if we're going to be in courtroom 25, whether that's really necessary. But certainly whatever logistically we have as far as equipment or screens or whatever is obviously fully, we would fully make accessible to defense counsel as well, as we do in every case.
All right. So, in Suffolk County, there are monitors. The audiovisual equipment is fantastic. There are the
Good.
jury seats.
Right on, sister. Let's go to Suffolk County. Let's go. Let's go. They probably got bigger courtrooms there too, where the public might actually be able to watch this trial in person. Or maybe, perhaps, what we could do is make this courtroom that you're currently sitting in an overflow room, like they do in many cases, where people can sit there and you have a screen or your big giant television. They just got Wi-Fi, so this is going to be touch and go. And maybe you could have an overflow room to accommodate the more than 10 media that are absolutely going to be descending upon your town come this weekend, and hopefully will boost your economy a little bit and be eating and staying in your hotels. And maybe you could accommodate them just a little teeny weeny bit. Oh my God. For the love of the traveling Mary. Really?
There for everybody to see. There's even a way if something is an objected to motion, it can just be seen on the lawyer's screen and the judges. So the bottom line is, if we had known about this 2 months ago, we would have been able to really put the time into seeing exactly how this works.
2 months
Ms.
ago.
Tinetti, I'd like to finish first, and I'll give you the opportunity to
I'm
speak.
sorry.
2 months ago, we didn't know that the jurors were only going to see the back of the witness's head, because we didn't know that we were going to need 19 witnesses, because a lot of people in this county have formed opinions about this case and absolutely know that she did not do this, Your Honor. And we didn't realize that, the other day when we thought we only needed one more juror, 5 jurors were going to come in with hardships and said, I don't want to be involved in this case. And then we had to really actually pick 5 or 6 that day. So now we got 19 jurors. So 2 months ago, really? They should have brought this 2 months ago? Come on. Stop.
Mr.
Stop.
Jackson, to really see how this works, see how we set it up. I can't devote that time to it right now. I don't.
What time
No
are you
monitors.
devoting?
No, I don't want to monitor. I'm not allowing, or Madam Court Reporter is fine. We're in that.
Melanie's getting mad. Melanie's getting mad. George is getting upset. George is getting upset. Name that reference. George is getting upset.
Very small courtroom now at your request. So
Your
we
request.
don't need monitors on the table.
At your request, because we thought it was perfectly acceptable that the jurors look at the back of a witness's head. We didn't think that that was important, but because you made a big stink about that, Mr. Yannetti, we have to move now to a smaller courtroom in this historical building. So, maybe you're going to have to take a step back on having your own AV guy come in here, because we just got Wi-Fi last week.
Tables. I don't have the time to physically go see how this all looks. Ms. Gilman's here. Perhaps she can speak with your audio-visual person, and then you can all make a presentation to me. But again, this months ago would have been much better.
Well, I understand the court's concern. This is extremely modest, and it's not going to take a whole lot of presentation. If the court doesn't want to monitor, the court says, I don't want to monitor.
I don't know if I want monitors on those tables so close to the jury.
That's
She's
fine.
motioning.
The court can say,
She's
I don't want
motioning like this, like that's how big the monitor is going to be. Come on, right?
monitors that close to the jury. Then what I would do is just use paper copies. When I'm up on direct or cross-examination, I don't want to have to, I can't prepare with the Commonwealth's.
No, I understand that. I don't think he'll fit at council table.
We'll move over, Judge.
Speak to that. I think he would. I think we could accommodate him.
How small is the
Or
council
if
table?
He doesn't fit right at council table. We've also set up, he was on a relatively large case that we had in a small courtroom back in California, and he set up just behind council table, and he's got his own laptop and nobody else can see it. He's got a type of screen that you can't see it from angles. So jurors are not going to be seeing anything, but I need to be able to, and Ms. Little and Mr. Giannetti need to be able to prepare with him. And I think the court.
No, I understand that. I don't have a problem with that. It's the 4 monitors on the tables, 1 on the bench, 1 for the court. We're in a small room.
We won't do that.
And I'm concerned about the amplifying sound. I mean, is it like movie theater sound? I mean, it's again, a tiny room at your request.
He uses very modest speakers that are appropriate for the space. So for instance, in this space, it would be probably a couple of speakers that are larger so that the jurors can hear, the court can hear. In a small space, he'll just pare it down and use small speakers. And there's a switch. So for instance, he will work with Commonwealth's AV expert, and there's a switch on both tables. When it's my turn, switch, and now.
All right, so is that switch, are you putting wires? I mean, these are all the things that I shouldn't be dealing with. I mean, we just got Wi-Fi in this building a week ago. I mean, it's not a building that.
I understand.
You know, we can just last minute. It's a beautiful old historic building. We want to keep it that way. So. And
we will not mess anything up. As a matter of fact, I was told that by the Commonwealth that she uses switches, consistently. That's not new technology. It's very simple. It just allows both of us to be able to prepare with the audiovisual portion of the case more seamlessly. That's all. We just want to make it more seamless and more professional for the court and for the jurors.
So it would be during your case in chief?
No.
It would be during my cross-examination of every one of the witnesses. I mean, the bulk of the case is going to be the Commonwealth's case in chief.
All right, with exhibits that are already into evidence, you're not trying to enter exhibits during cross-examination?
You're not just going to put stuff up
unless it's an impeachment that I didn't see coming. But even in that case, my habit and practice, my custom and practice would be to approach, if it's a matter in controversy, or tell the Commonwealth in advance, I'm about to show this photograph. Do you have any issue with it? No, I don't. And then we'll show it. But I would never, the point of it is not to ambush anybody. It's just to make what is going to be shown and what's allowed to be shown seamless and more professional looking.
Mm-hmm. Yeah, and don't they have that right?
Does the Commonwealth and Ms. Gilman have an opportunity to spend a little time today to take a look at it and see? I mean, everybody's preparing for trial, obviously. Again, this is
such an
I don't have the time to do it, and I understand if you don't, but.
And I understand if you don't.
I think Ms. Gilman can spend some time. She actually had made arrangements to meet Mr. Bates here last Friday, and he didn't appear when we were told.
He didn't show up. He's going to make it like the AV guy didn't show up. Listen to this.
Well, he was going to be here. So, but I'm happy to have Ms. Gilman.
Ms. Gilman, are you willing to spend some time today? Thank you.
By the way, just on Mr. Bates's defense, yes, he was supposed to come last Friday. He was told he couldn't come because he hadn't gotten permission from this court yet.
Okay.
We did not.
Well, that makes sense, frankly.
I just didn't want there to be a sort of a hanging Chad where that's concerned. He didn't leave.
Well, especially where he didn't start out well, right? Being at council table during impanelment.
I understand that. And he's been told that was inappropriate and obviously would never happen again.
All right. So some sort of ground rules. Only one counsel, whoever's doing the cross-examination of the witness, objects. Just one, not all of you. It's not a tag team.
Yeah, we
So
went over this
one
before.
person objects. If you want to approach the witness, you must ask permission. At
Yeah, don't just
sidebar,
run
there
up
will
and
only be
yell in the
one
witness's
person
face.
talking again, and it'll follow with whoever does the examination. Many times I allow counsel to discuss things, and many times I call directly on maybe appellate counsel or counsel who's been the big law person. So you can ask me for permission for that, and no basis for your objection. You just simply object. That's it. And
Yes,
if
ain't
we
no
need to
basis.
see you at sidebar, we'll see you at sidebar.
No
But
basis.
I don't want a whole litany of reasons why the testimony you think is inadmissible.
Yeah, because we wouldn't want anybody to know that it's hearsay or badgering or anything else like that. And then she says, bye-bye, everyone. See you Monday at 10. So we're going to see her Monday at 10. But let's check in here because this is wild. This is wild. And if you're just tuning in and you don't know anything about this case, or do you think it's wild too? I don't know. Perhaps you just might. Thank you so much, Lisa, for your donation. Says, thank you, Mel. I appreciate you. Lisa, you have no idea how much I appreciate you and how much you make me keep me sane, all of you. And Darlene, thank you. She says, actually, that's funny. She says, thank you for a little bit of sanity. Thank you, guys. And you know that YouTube takes 30% of super chats. So I put the little scanny thing up there in case you feel like, being generous today. Let's see. We also have to thank Jerry. Thank you, Jerry, so very much with a little gift emoji. Thank you, Crime Genie, for buying me a matcha latte. She says, love your coverage on the Karen Reed case, smart and classy. Thank you so very much. Somebody else sent me a little tidbit here. Donna says, cross-examination is not limited to direct in Massachusetts. That is very, very interesting. And she says, and what is so disappointing in all of this is that as a prosecutor, you're not supposed to be concerned about a win or a lose. You're supposed to be seeking justice. And that is for every citizen of the Commonwealth, including the defendant. Amen, sis. Anne Marie, thank you so much. She says, in this dark world, your sparkles are so welcome. Thank you. Thank you so much. I appreciate you so, so, so very much. All of you. All of you guys. You guys are amazing. Elaine, thank you so much. I received and I thank you so very much. And Anne Marie, thank you. And Anne, thank you very much. Anne says, thank you. I love your show. Thank you for watching so much. KK, thank you for the matcha latte. You guys are friggin' awesome. And Erin, thank you so much. And says, for thank you. I always look forward to your streams. I always look forward to hanging out with you guys. And Stacy, again, for the incredibly generous donation. She says, you are such a scrapper. Thank you so much. Emmy says, I love your pink sparkles. Thank you, Melanie. Listen, girls, don't ever let anybody dull your sparkle. That is my advice of the day. Don't ever let anybody dull your sparkle. I've been telling my kids that since they were little, and I'm still telling everybody that. Emmy, don't ever let anybody dull your sparkle. Kimberly, thank you so much. She says she appreciates me. Thank you, Kimberly. I appreciate you so much as well. You can't make this up, you guys. It's like every day it gets crazier and crazier. We're going to be back on Monday, but before we do that, because we have a whole bunch of other people to thank here, let's take a look, because I think that there are some people out there in the rough, tough, disgusting social media world who don't really understand the difference between fair use and defamation. So we're going to have a little class right now, or a little primer, let's say, on defamation law in New York, because that's where I'm located. So there are a couple of things to prove under New York defamation laws, and obviously the law of where the person that you're harassing or defaming resides is going to be the law that governs, because for those of you, some of whom may be defaming people on social media who claim to be in law school, you might want to pay a little bit of attention in torts class. So torts is a thing. Defamation is a tort. And in New York, defamation is defined as a false statement published to third parties that exposes a person or entity to hatred, contempt, aversion, or to induce an unsavory opinion in the minds of members of the community. The heart of a valid claim for defamation in New York hinges on whether or not the statement caused damage to the subject's reputation. Okay? Therefore, there are certain things that are called per se defamation, which automatically qualify as defamation. And they are statements charging a plaintiff with a serious crime, statements that tend to injure another in their trade, business, or profession, statements imputing a loathsome disease on a plaintiff, and statements impugning unchastity or imputing unchastity on a woman, like cheating on her husband or something such as like that. That's per se defamation in New York. So you don't have to prove any injury. All you have to do is prove that the statement was made. See, that's how it works. Reputational harm will be presumed if you, let's say, accuse a woman or go on camera and say something about a woman that imputes unchastity to her. So here's what you need to prove defamation in New York. You need to prove that the defendant made a false statement. You need to prove that that statement was published to a third party without authorization or putting it out there on the internet. You need to show that the defendant was at least negligent when making the statement. And you need to show that the statement caused special harm or constituted defamation per se. And when you are going to defame someone who actually has a profession or a license, and you're going to tell your minions to go after them and come after their license, that's defamation per se, my friends. And it's not really a very high bar to prove it. So we're going to take a look at some things, and you're going to tell me whether you think the elements of defamation are made here. Okay. So here's what we're going to look at. Hang on one second. And then you do not want to go to court in New York. Promise you. Yeah, promise you. Very defamation law for dummies. Yeah. So here's an example. Let's take a look at this first. And I'm hoping the audio works on this because this is classic. I don't know this person personally. I've never really watched any content that this person has ever created, but one of you was kind enough to share this with me. And so I want you to listen to this and tell me if you think that this meets one of those definitions that we just looked at of per se defamation. Let's take a look or a listen to this. Let me know if you can hear it. Oh, crap. Crap, you can't hear it? All right, I'm going to have to pull it up another way. I'm going to have to pull it up another way. Hang on one second. Some reason when you pull it up through, you can't share the audio through StreamYard. If any of you guys know how to share audio on a window through StreamYard, let me know. Or if I have to play it through a tab. All right, I'm going to have to play it through a tab. So hang on, I'll find it. That one's going to be fun because we're going to look at that in a second because it personally attacks me and actually accuses me of I couldn't even believe this when somebody sent it to me like, what? Like, what? Like, why am I even involved in this video? Why is this person mentioning my name in this video when I'm not even there? Okay. Oh, it's through the settings, huh? Well, I know how it says like share audio of. All right. Well, I can get it a different way. Don't you worry, my friends. Don't you worry. But before we go there, we're going to also talk about the federal law against doxing, okay? Because that's some interesting stuff too. So I told you earlier that there was a threat against me yesterday, a very credible threat, in fact. And it's been handled. It is being handled. I am going to tell you this. I'm going to be classy about this right now. Okay. And I am going to, because that's the kind of woman that I am, unlike some other people. If anyone knows who this person is on Twitter, IP addresses and stuff are easy to get, and all that stuff is in the works. But anybody who knows who this person is on Twitter, who is convinced that I am somebody on Twitter called Haley Walbrecht, which I am not. I deleted my Twitter. I don't know who Haley Walbrecht is. But when you start posting things like TikTok, 5 o'clock, I'm going to start releasing pictures of your house, and I'm going to release your address and all of your personal information, that becomes a federal crime. Okay. You know who you are. You know that you are watching, and I am going to give you an opportunity to take that shit down. Okay. I'm going to give you this opportunity because I have class like that. Okay. And when you start putting on there this unhinged thread about me and how this stuff is so disgusting that I'm not even going to read it because it is foul. It is absolutely foul. It goes on for what seems like days. And then at the very end, you say, so here's the thing, Mel, I do have a lot of private information about you. Seriously, you are way too open for someone who still has children at home. Because of that, I just can't be the one to put the rest out there. I can be an a-hole, just not that kind of a-hole. Of course, this person did not actually not say those words. I did think you might actually care more about their safety than I do. But yet again, not Haley wins. I should have known. You act like a savior while things around you go neglected. You're no savior. You're a tormentor and a narcissist. I don't know who you think I am. I don't know you. I've never met you. I have done nothing to you. And I'm going to give you the opportunity to get that shit off of Twitter like now. Like now. And I'm also going to ask you nicely to take down all the videos that you posted of mine where you stole my content and you made a little YouTube channel all about me. Okay? Before I copyright strike you, because I am done. I am done. You have been asked nicely by this person that you think I am, who has already agreed to testify for me in court. And you come for me and my children. You're going to have a problem, lady. If you are a lady, you say you're a grieving mom. And I posted something about you once and I took it right down because I felt bad for you. I felt bad for you. And if you are a grieving mom, then my heart breaks for you that you lost a child. But how dare you come for me? This is a federal crime. You don't know what you're doing and you need to get control of yourself. Got me? You feel me? Disgusting. It's disgusting. And I'm not tolerating it. Yeah, Clara, these people do not have feelings. And you know what? I'm going to handle it. Like, I'm going to give her an opportunity to take this shit down. But yeah, this is frightening. This is frightening. I have spent my life helping people. How dare you? TikTok, 5 o'clock. I'm going to release all your private information. Really? Is that what you say you do here with your 30 followers? Or 200 followers or however many, and it didn't get a lot of views, and that's not the point. The point is this behavior cannot be tolerated. I don't know what kind of cesspool you live in over there in Twitter world, but I'm going to give you an opportunity to take it down. Got me? And if anybody knows who this person is, please reach out to them. I'm sure you're watching right now. I'm sure you're watching right now. And whoever it is that is Haley, would you please come out? And I know that you've posted that I am not you. I don't even go on Twitter. Never have. I had by the time I deleted my account, maybe 10 tweets. Okay. So not happening. Not happening. This is what I get for reporting on a case that I feel passionately about because I can't believe what is going on here. And none of you should be able to believe what is going on here either. And to this woman, okay, this is what I would also call per se defamation. Let's take a look and let's listen to the actual, we'll go back through the elements of defamation because this person does not seem to understand what the elements of defamation are in New York either. Okay. She says, Ms. Coffendorfer, on her tweet to her 100,000 people who viewed this, by the way, Such a great example of the propaganda in this case, yet media gives the audience. And poor Miss Little does not even know the autopsy photos are not available to the public. You can clap back on that. No, or perhaps did she not misspeak and she has them leaked to her by the hashtag Karen Reed camp? So she actually hashtag Karen Reed. So everyone who's got that in their search bar will pull it up that I am spewing propaganda. I love Joseph Scott Morgan. He isn't going to subscribe to a false narrative. And then attaches a video of me and Turtle Boy. And as of earlier, when I was sent the screenshot of this, this has 103,000 views. Okay. So let's take a look at defamation. Did this person make a false statement that I'm spewing propaganda, that the autopsy photos are not available to the public? The autopsy report isn't, but I didn't talk about the autopsy report. I talked about what was in the court documents on that stream with Joseph Scott Morgan. And you're accusing me now of having documents leaked to me by the defense team. Okay. So you're accusing me now of an ethical violation as an attorney publicly to 100,000 people. And this statement caused special harm to me. So yeah, you're trying to destroy my credibility. You're trying to destroy my business. You're trying to destroy any, I don't know, what? Legal consulting gigs that I may be able to get. This is per se defamation, my friends. So I'm going to give her an opportunity to take this down as well, because this is actionable and perhaps maybe she should consult with her attorney, because I'm sure she has one on retainer. This is mind numbing that somebody with this reach would choose to go after another woman in this business with zero respect. Here's yesterday's tweet by the same person. I say this in all seriousness. Is this a fashion show or a trial for your life? Mini skirts and thigh-high leather boots? She just does not care. Hashtag Karen Reed is accused of murdering hashtag John O'Keefe. Hashtag justice for John O'Keefe. Are you kidding me? And then another tweet about me to Rosalie, who also seems to have a target on my back. Rosalie, maybe you better go back and consult with your attorney as well. It is J.O.'s hair. This is about the hair. She is a clueless woman trying to destroy my credibility, trying to ruin my business, trying to have your minions come for my law license, because that's in here too. You didn't say that. One of your minions did. Again, about me, she is a personal injury attorney. She has zero criminal experience. She is in this for the money. Oh, I'm staying strong, Lola. I'm staying strong. I'm just calling it out where it's calling out. Like you think that you can just get away with defaming people with professional licenses and trying to attack their credibility publicly to your 100,000 followers? Disgusting. Disgusting. It is vile. It is vile. You're right. Oh, Kevin said horrible things about the other day about me too. Okay, well, you know what? He doesn't really have much of a reach. So, you know, I don't really. I mean, he's a, you know, living in his mother's attic. I mean, really? Like, go ahead, come for me with your 20 people who listen to you. I don't care about that. When a woman who is supposed to be a professional comes after another professional woman, and this is really, this is what you're publicly saying about me? I got a problem with that. I got a big problem with that. But let's see if we can pull that video up another way, because somebody pointed this out to me, and mind-numbing, again, mind-numbing that this would even be, I would even be a topic of conversation when you had the opportunity to yell questions at Alan Jackson, that you would ask him about whether he had fun with me in Cancun a month or two ago. Twice. It's in the video twice. I got to find it now. Now I got to find it. Hang on. Because, I mean, we're into it now, so we might as well go there. Oh, and feckless millennial, your little video about me calling me a fraud, again, per se defamation, because you are doing that with the intent of ruining my reputation as a professional attorney, whether or not you think that my civil litigation experience actually gives me the credibility or the know-how or the professional experience to be able to opine on a criminal case. When you start calling me a fraud in your little shorts that nobody watches, that's a problem. You may want to consult with your attorney as well. So, the fact that you seem to think, and all your minions seem to think that this is totally okay, is just mindless. It's mind numbing. Mind numbing. Because you don't understand the law. This has nothing to do with fair use. This has to do with defamation. And there's plenty of more out there too. I don't even have all the time to address all of these, but I got to find this other video because you're just going to be blown away by this. How me saying that Alan Jackson's bracelet looks like something that I got when I was in Cancun at the Dave Matthews concerts turned into something that me being in Cancun with Alan Jackson is it's just beyond. If anybody can send me like the Twitter link to that Grant video, I can't find it right now. It's so buried in all of his ridiculousness that I just can't even find it. So if you have me on speed dial, like you can't even believe this. You can't even believe that this guy is yelling at Alan Jackson. Did you have fun with Melanie Little in Cancun? Did you have fun with her? All right, I'll have to go see what Kevin wrote. But, as a little, doxing is also illegal, as is threats to dox, and it's a federal crime. So, like, really, do you want to get involved in? Oh, and then there's Mrs. Chat GPT. Yeah, she made a cute little video too that is, obviously targeted at ruining my reputation and my business and coming for me. So, yeah, no, I don't really even know anything about JLR's video. It is that video. Yeah, he's in that video too. But at the end of the video, he actually starts yelling at Alan Jackson about whether he had a good time with me in Cancun. And look at this woman. She's making up not only a video, but a flyer that I'm a social media person for the, look, there's my name right there. Melanie Little, public relations officer. I am not a cupcake at recoveringattorney.com, designed to make everyone think that I am hired gun for the defense, which I am not. And the truth will set you free. It's disgusting. It's disgusting. You're all gross and you're all better want what you wish for is all I'm saying. Kelly, thanks for your super sticker. Della, thanks for, are we living in the Matrix? The whole thing is ridiculous, 100%. It is. Paul Cristoforo, thank you so much for your super chat. With my ever heavy sigh, I'm waiting for Luke Skywalker to show up looking for his father. Yes. Maureen, thank you so much for your super chat. Thanks for splashing Bev's mumbo jumbo. Lexala, thanks for your super chat. What's your biggest concern about the fairness of the trial and for Karen going into this? Going to be the exclusion of certain evidence that we need them to be able to talk about. The internal affairs of investigation, the federal investigation, and none of that stuff has really been ruled on. It's going to be on a case-by-case basis. But I am confident that the defense knows exactly what they're doing, and they're going to know how to get a lot of that stuff in. So I'm not really that concerned. I feel good about this. I have a great sense of justice, and I think it's all going to come out. Della, thanks again. Most are related, and Bev rents her property to them. Yeah, that too. Ivy May, thanks for your super chat. Melanie, I saw a classic movie recently and couldn't believe how much you remind me of Lauren Bacall. Oh, that's very nice. I hope you like her too. She was no cupcake either. I do love Lauren Bacall. Della has a mental crush on Yannetti. Smart, savvy, and a class act. Yep. Thanks, Amy. In Boston, your Marcy's impression is killer. Lisa, thanks for your super chat for a lifelong Deadamite. You rock. Your accent is so Ted Kennedy. It kills me. Thank you. Aaron Hack, Boomer Bev. I think I pulled that up before. And Lala, thanks for your super chat. And Heather Reed, thank you for your super chat. Murder runs on Duncan. Mozzie says, please, I'll just go there and teach her how to be an unbiased judge. Bev is in denial and has no idea the world is watching her and cringing at her every word. She's lost herself in Lally's rabbit hole. Yeah, seems that way. And again, thanks another one. And Lala says, at the end of court yesterday, Auntie Bev pulled the defense and the Commonwealth to the bench to discuss about a particular juror. Do you know what that was about? No, I do not. LTL, thanks, Brian, for coming in and becoming a new member. Go subscribe to LTL and the Glare. Thanks. Heather Reed, thanks for the swear jar. $2 donation. Maureen Francis, thank you again for your super sticker. You are so generous. And again, another virtual donation from Maureen. She's just always in here. And Lisa, thank you so much. Magnolia Gypsy, thank you for money for the swear jar. That's awesome. I think they were all going to be swearing a lot during this trial. And today, Heather, again, for the swear jar. Diane, thank you so much. When you look up the definition of keyboard warrior, Coffindoffer's image is there. Oh, but like when it crosses that line, when you're intentionally trying to destroy someone's professional reputation, that's where I have a problem. You know, where you are posting a little video about Melanie Little is a fraud and she's paid by the defense and she's a shill and she's a grifter, that's going to destroy my professional reputation as an attorney. So I think if you're going to make those videos about somebody who has no job and doesn't really have anything to lose, you're probably better off. But once you start attacking professional, successful people, you might want to take a step back. I don't know, consult with your own attorneys. That's all I'm saying. Yeah, let's unpack that. Thanks for your super chat. Enough is enough. Sue her and start sending cease and desist. We got your back, Melanie. Thank you. Thank you so much. And I do appreciate all of you who go and defend me on that cesspool because it's really beyond. I mean, if she's looking for views on her YouTube channel, like I don't even know what is going on there. Oh, the New York Post is calling me. I'll have to call them back. Thank you for your super sticker so much. On top, Paul Lynch for the super sticker. Thank you. Jennifer Jansen, stay away from the mean girls. Jennifer, they are everywhere, man. They are everywhere, girl. You cannot escape them. You can't. LTL, we're all paid. I thought everyone was in on it. I'm still waiting for my check. Me too, Bri. I'm still waiting for my check too. You know, but here I am, the public relations officer of I am no cupcake at recoveringattorney.com. That's me. That is me. Latina, did you see the discovery Turtle Boy got from the false arrest woman? I shut Kevin down on YouTube for you. You can go see it in the comments. Thank you so much. I did not see the discovery. Yeah, I think they got an extraction of her phone, but no, I have not been as up on that case as I would like to know about it, but I did not know. I heard he got the extraction of her phone, that woman, Lindsay, who pretended to be pregnant. Mary Rothman, thank you so much. You were way out of her league. Thank you for your very generous super chat. You guys, I don't even know like what to, you know, when you know that when Will the Glarer is speechless, and I've seen a couple of comments from Will who's never speechless, it was just like, wow. Like, you know, you're onto something. So thank you, Suzanne, for emailing me. Let me see. Did you email me the video? Because I need like the actual link because I can't pull it up. Like I had it downloaded because that's how somebody sent it to me. Give me 1 second. Latina, I went after Grant, Kevin, and Andy. Oh, we know who Andy is. And yeah, Kim Ferris. Yeah, I have all our information if you want it. You know, listen, these people want to keep trying to ruin my reputation. It's just not. Oh, there's a new Grant post on me. Oh, excellent. Because we're here anyway. So let's go for it. Let's see what he has to say. He's just a law student, though. I mean, I don't know. Is he first year, second year? Do we know? Hello, attorney. I spelled my name wrong. If you publish those court documents as a threat to Lindsay, I will not stop until I get your law license. Publish what? Threat to Lindsay who? Why would I publish anything that has to do with a case that I'm not even covering, Grant Smith Ellis? Those documents are protected by court order. You have ethical obligations, counsel. Really? I think, Grant, I think what you need to do is to go back to torts class and learn about the intentional tort of defamation. I just went over it just now. So you might want to take down your little video where you accuse me of having an affair with Alan Jackson and going to Cancun with him. So, you know, there's that. Good luck with that, dude. Good luck with that. You want to come for me? Go right ahead. What are you're sending me a warning on what I'm allowed to do and not do as an attorney? Trust me when I tell you that I am perfectly aware of my ethical obligations, unlike you. Unlike you. So, yeah, I know exactly who he is. I've heard all about it. So can somebody please send me that video with Alan Jackson where he talks about me and Alan Jackson? I need you to see it because it is so freaking unbelievable that you just can't even, like, you're in the twilight zone. That's like so buried here in his nonsense. Anyone? I'm going to find it. I'll find it and we'll listen to it next time. We will listen to it next time. Yeah. Oh, thanks, Suzanne. Oh, there it is. From Grant right now, Melanie, if you publish those court documents as a threat to Lindsay, I will not. I don't even know who Lindsay is. I do not even know who Lindsay is. She's the woman that pretended to be pregnant. Is that her? I don't even have access to that documents. I don't care about those documents, Grant. I'm not covering that case here. I will not stop until I get your law license. Oh, well, there's another threat. Is she your girlfriend now? Like, why are you so personally invested? Solomon Landscaping, thanks for your super chat. Coffin Clown is jealous because she's not the brightest bulb. Well, you continue to. Some people, I guess that's what it is. I guess that's what it is. So, you know, people should just guide their actions accordingly, consult with their attorneys, and figure out that if what they're posting is not designed to, under the laws as such of the state of New York, defamation laws intended to destroy someone's professional reputation before they post their bullshit. Okay. Joe Kane, thank you so much. And he says, ignore all the trolls. Your coverage is superior between your intelligence. They cannot stand your sparkle. Thank you, Joe. And thank you, Christine. And I appreciate that too. Please apply this to a defamation suit against Coffindog. What a maroon. What a maroon. You know, here's the thing. It's not going to cost me anything. That's the thing about being a civil litigator. Is that you're well-versed in civil litigation, as if that's some sort of like a dig. You know, boundless millennial too. They did this to Olivia Lambeau too. Yeah. Latino T. Well, guess what? I'm not taking it. So thank you for gifting a membership, Deborah. That's really, really sweet. The thing about being a civil litigator is this is what I do for a living. It's what I do. Civil litigation, harassment cases, defamation cases. It's my wheelhouse. I tried to be nice. I mean, I tried to be nice. I'm going to give you an opportunity to take it down. So, Patty, thank you so much. He's a second year. Yes, thank you. Love the Defense Diaries. Would love to listen to you and Ali Mata. Perfect pairing. All right, my TED Talk is over. My rant is over. But you know what? I'm not going to shut up. So you can keep, posting whatever shit you want to post. Guide your actions accordingly. I'm sorry. Oh my gosh, if you have kids in the room, I'm so sorry. Thank you, Debbie, for your super sticker. Because I don't curse on this channel, but I'm done. I'm done playing in your little sewer, letting you think you can post whatever you want to post. So for those of you, thank you, Debbie, who think that you are going to shut me up. And I wonder if you'll retract all this stuff when you find out that you were on the wrong side all along or not. Thank you, Alex. I appreciate that. Check your email, says Kimberly. Okay, thanks, Kim. Yeah, let's see. Oh, yeah, you. Oh, this is awesome. Thank you. Kimberly wins the day. Thank you so much. Okay, remember we read about the per se defamation, and that's where you post something about that a woman is unchaste. Well, let's take a look. And you tell me if you think this meets the definition, because I'm done playing. Okay? Haters going to hate, and I'm done playing. So let's go, my friends. You're not going to believe this if you haven't seen it. Or maybe you will believe it.
All right. Good morning.
Hey, Karen, are you prepared to spend the rest of your life in prison, Karen? How's it feel to be known as a cop killer, Karen?
Yeah, that's for those of you who don't know,
To be known as a
that's-
cop killer. You're going to prison, aren't you? Right?
the guy in the red sweatshirt, his name is JLR from JLR Investigates.
You have any remorse, Karen, for what you did to the O'Keefe family? You have any remorse, Karen, for what you did to the O'Keefe family, huh? Will you denounce your supporters harassing the O'Keefe family? Will you denounce your reporters harassing the O'Keefe family, Karen? Shame on you, Karen. That's what people say. Karen, anything to say, Karen? You're going to spend the rest of your life in here. Don't touch me. Don't touch me.
And he's proud to post this like it's some sort of journalism. Yeah, do not give anybody any views on this shit. Then I'm sorry. Again, I'm sorry on any of this stuff that I'm talking about. Don't even give him the views, you guys. Don't do it. I'll show it to you. We can all view it together.
Don't touch me. Karen, you're going to spend the rest of your life in prison, ain't you, Karen? Yeah, you are, Karen. Karen, you are, aren't you? Watch out. Karen, you're going to spend the rest of your life in prison. Right, Karen? How's it feel to be known as a cop killer, Karen? How's it feel to be known as an asshole? Be known as a cop killer, Karen? How does it feel to be known as a cop killer, Karen? How does it know? How's it feel, Karen? How's it feel?
This is
Karen,
Grant's
how
video,
did you
so-
manage to walk into Josh Levy's office in November of 2022? Do you know him? Does your father?
Karen, how's it feel to be a cop killer?
Mr. Jackson, did you go to Mexico with Melanie Little in the recent months?
Karen, aren't you?
Did you hear that? Mr. Jackson, did you go to Mexico with Melanie Little in the recent months? Really? Let's just roll that back for emphasis, because like this is what you're going to ask Alan Jackson. You have one of the best defense attorneys in the country in front of you, and this is what you choose to ask about me? I'm sure he doesn't even know who I am. Like, are you kidding me?
Did you go to Mexico with Melanie Little in the recent months?
Karen, aren't you? How's it feel to be a cop killer, Karen? How does it feel to be a cop killer, Karen? Shame on you for what you did to the O'Keefe family. Shame on you, Karen.
How was the trip to Mexico with Melanie Little, Alan Jackson?
Again, twice. Don't believe everything you read in the comments, Grant Smith Ellis. If you'd like to go back and talk about where this came from, when I came back from seeing Dave Matthews in Cancun, Alan Jackson was wearing a bracelet in court. And I said, oh, that looks like a bracelet I got, somebody gave me at the Dave Matthews concert in Cancun. I wonder if he went there. And this is what they have twisted this nonsense into. Some woman came into my comments. I think her name was Kerry. And she said something like, oh, is it true that you went to Cancun with Alan Jackson? I said, where did you hear that? Don't believe everything you read on Twitter. And she said, oh, I just saw a video of you and Alan Jackson in Cancun. And I said, well, that's ridiculous. And it's not true. So again, we're going to go back to the defamation. I don't think we need to, but you tell me whether you think this is defamation or not.
Karen, how does it feel? How's it feel, Karen? How's it feel?
Karen, how did you manage to walk into Josh Levy's office in November of 2022? Do you know him? Does your father? Mr. Jackson, did you go to Mexico with Melanie Little in the recent months?
Karen, aren't you? How's it feel to be a cop killer, Karen? How does it feel to be a cop killer, Karen? Shame on you for what you did to the O'Keefe family. Shame on you, Karen.
How was the trip to Mexico with Melanie Little, Alan Jackson?
Really? That's what you choose to ask him? That's what you choose to ask him. You can ask him anything you want, and you're asking him about me. He doesn't even know who I am, dude. But good on you. That's some really great reporting there. Really great reporting. Hello, Jason Smith. Thanks for coming in. I put some new emojis in there for you. Little Steely. Thanks for your super chat. Hey, now, Mel, I've seen all the rewinds lately, and you are doing an awesome job analyzing a dumpster fire of a case. This YouTuber shouting outside the courthouse has some skeletons of his own. I wouldn't even go there. I'm just like, just take it down. Just take it down. Because you trust me. I'm a civil litigator. This is what I do. Like, okay, if that's what you want to do. Thanks, Sandy, for becoming a member. Thank you, Anne Marie. Keep on keeping on. I'm trying. It's a lonely island out here sometimes. Lizzie, thank you so much. Looking forward to your interpretations next week. I can't wait. I can't wait for this to be over. I can't even imagine what the family is feeling. Family of John O'Keefe and the family of Karen Reed, my heart and my prayers, and Karen and all of you, I'm with you every step of the way here. When I first started reporting on this case, I did not form opinions, but the more I dug into the evidence, the more I absolutely know, as the federal investigation found, the FBI said it too. A car did not hit John O'Keefe, and John O'Keefe was not hit by a car. Thanks, Leah, for joining. Wondering your early impressions of the judge. Oh, early. We've been doing this for a long time. But listen to the beginning of the stream and the middle of the stream. And I think that, a lot of her rulings were fair, to be fair, with regard to what's coming in at trial. And a lot of them we're waiting to see. So it's going to be a day by day. It's going to day by day. Do you remember that song? Oh, dear Lord, 3 things I pray. Oh, man. Nikki, thanks for your super chat. You're the absolute best at Melanie. We love you. She's jealous of me. Thank you. I'm outraged with you and for you. Thank you, NDF. And thank you, Latina. I'm not sure if that person got fired. I'm not putting that up, but I'm going to thank you for the super chat, for applauding JLR. I don't know. Listen, I don't think anybody should be doxxed ever. And what that person did to me yesterday with a TikTok and a thing. I mean, it's federal, it's a crime, and it's being dealt with. But I'm going to give her the opportunity to take it down. So it is no joke. None of this is a joke. The buffer zone is a joke. It is. All of this is a joke. But does anybody know the score on the Ranger game? Okay, because it is hockey playoffs, and we've been here for 3.5 hours, and I love every single minute that I spend with you guys. You know that I do, but my Rangers are playing right now, and I got to check the score. Okay, we're winning. 7 minutes left in the second period. All right, so I can make it for the third period. Okay. Thank you. This is crazy. Like, this is what's happening to people who are talking about this case. And I guess now I understand, being relatively new to this YouTube world, since I only started this channel all the way back in like July of last year, that this is a vicious, disgusting place. You need to give me a screaming goat, please, day by day. Thank you. Yeah. So let's keep going. Let's keep on keeping on, and just know that we are going to see, I think, some justice served very, very soon. Hopefully, Monday I will be here with you for opening statements at 10 a.m. So yes, I will be live streaming the trial. I think Brandy and I may do something together. We have to figure it out time-wise and all that stuff. And let's keep on keeping on. To my moderators who are the best on YouTube, thank you for always keeping me safe and keeping my chat safe and keeping people safe who want to come and have a place to act rationally and talk like normal people and have conversations. Thank you for that. And oh, you're right. I got to call them back. Okay. Thank you. And to my viewers, replay viewers, please hit the channel members. You guys are awesome. Hit the like button. It really helps the algorithm. And if you could just hit the subscribe button, please do that too. It's free. Doesn't cost you anything. Gets the information out there, gets the stream out there. Otherwise, what happens is we get shadow banned. Nobody wants to be shadow banned. So, keep on keeping on, my friends. And remember, as always, as I say to you, be cool, be kind, be classy. It is not hard. It is so not hard unless you are a feckless millennial, AKA Matt, or you are some chick who likes to drink a lot of wine, whose name might actually be Karen. Or perhaps you're Mrs. Chat. Talked about that. And somebody named Heels Up or somewhere, who may be also known as Vicky. And that millennial whose, fake name is Wolfgang Bodie, AKA Matt. And what is it that Socrates used to say about people when the facts aren't on your side? Slander becomes the tool of the losers. Yeah, remember that. And also, remember, my friends, be cool, be kind, be classy. It's not hard. Really. It is so not hard. Well, I mean, for some people it is, but not for us. Peace out and stay safe out there, my friends, because it's a wild, wild world. In the words of Cat Stevens.